One will be appointed to you now. Okay.
Officers were dispatched to a location, a residence in Harris County, Texas, in reference to a theft. Upon arrival, law enforcement met with the defendant, who stated that she let the complainant borrow
To go forward with your case as a condition of your bond, you're ordered not to be in possession of any weapons and not to have any contact with this complaining witness and not to go where they live or work. If you violate these conditions, I will revoke your bond, put you in jail. There will be no more PR bonds for you. Do you understand, ma'am? How old are you?
18.
What do you do for a living? Nothing.
I don't want it.
Why?
I was graduated.
What?
I stopped college 16 something.
Great. Are you actually enrolled in college?
Huh?
You
Okay.
actually enrolled.
Mm-hmm.
You're going to start.
Yes.
Okay. How do you think this helps? You know, employers look at a multitude of things when they're hiring people. They look at records, they look at criminal history, they look at grades, and the more stuff you pick up, you think it gets better, you get worse. Miss Edwards, does it get better or does it get worse the more criminal cases you pick up? Keep that in mind, ma'am. We can have you fill out in a court for a court-appointed lawyer. We will have bond conditions created for you to sign. Do not endanger my community. Do you understand, ma'am? Hello?
Yes.
Yes, sir.
I mean, should we just reset the case?
Judge, she did send an email requesting to reach the hiring attorney, and when I tried calling her, she was on that.
Oh, because I was already in here. My phone.
Okay, we'll do THA then.
Okay.
Okay, all right. Please, just do not leave until you sign the bond conditions, ma'am.
All right, Judge, council
Hi,
approaches
Mr.
for 14 and 15, Segovia and Signal.
Yes,
Ms. Edwards, right this way.
so there are actually two different offense reports written by two different officers. So we could start.
Are you here on the motion to sub?
Is that, and he's gotta be the RN, he's not on that.
Got it, okay.
All right, I'm getting both sides.
Michael, you,
Segovia first and then second. If we could do Mr. Segovia first, there are actually two different offense reports written by two different officers,
two different transactions?
same transaction. And the information is the same, but it's written by two different. One officer, it's basically a long game of telephone on each one.
Oh, Lord.
So this one is the longer of the telephone conversations.
All right, gentlemen, both of you are charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. Both of you speak English?
Yeah.
We are going to do probable cause. You have the right. That's Segovia.
This is Mr. Segovia. and this
Got
is
it.
Mr.
All right, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
The officers were driving on our sheriff's office vehicle in Harris County, Texas, when they observed a white F-150 and a black Mustang driving side by side. The vehicle simultaneously slowed down to 45 miles per hour in a 65 miles per hour zone, and then both accelerated to speeds of up to 120 miles per hour. Law enforcement were able to capture footage of this on their department issued phones. Law enforcement advised marked units of the incident, and they were able to conduct a traffic stop on both of the vehicles, which were both in these defendants, Judge.
Who's in the truck?
That's what I'm trying to.
Mr. Sino was allegedly in the truck and Mr. Segovia was allegedly in the truck.
In the what?
In the
Mustang.
Mustang, in the black.
Okay.
Here's the important thing on both. So both have very similar information. They both have, essentially the same set of facts.
Okay.
And the observations of the witnessing officers are relayed in the same manner. They talk about how one client is in lane 1 and the other is in lane 2, and that they slow down 45 and a 65, and then they accelerate. What is missing from both of these reports is that they were ever lined up from a point side by side and accelerated from that point. So one lane 1, one in lane 2, and then they accelerate is not racing. And the speed is irrelevant to racing because there's no element of speed in this offense. So while they're both written by different officers, it relays the same information that there is a lacking element witnessed by the officer, which is that lined up point side by side.
So Judge, they indicated that they were participating in rolling drag racing. They indicated that the officers was able to report this into his phone, that it is correct for the Ford 150 was in lane 1, the Ford Mustang was in lane 2. They're both going together. Ford Mustang slowed their operation speed before accelerating at a high rate speed, participating in a rolling drag race. The other officers that conducted the other traffic stop did observe that video and also determined that they were both.
If they're saying it's a drag race, then the definition of a drag race is 2 or more vehicles from a point side by side at accelerating speeds in a competitive attempt to outdistance.
So I understand that, and I'm very happy that once again the officers included the definition of a drag race. And then, next section, they write about their observations of what they saw, and they saw 2 vehicles, one in lane 1 and one in lane 2, slow down and accelerate. However, in that observation, the personal observation of the officer, not the definition of racing, they never say that either of the vehicles were lined up.
He said they're in a drag race.
Well, I understand, but that's defining the word with like you can't define the word with the word you're defining. So I'm glad that they know what the code says about racing, but when they talk about their observations, there's a disconnect between that because they don't mention that either of these gentlemen were lined up from a point side by side and accelerating from that point.
But drag race does say that.
The definition and the code says that.
I don't.
But
And Judge, it makes the court feel better. Looking at the PC statement, they do indicate that these vehicles were driving side by side, aligned. The vehicles aligned. A rolling drag race begins once the vehicle accelerates simultaneously side by side in an attempt to outdistance outgain each other. They defined it in their offense report, but they indicated in their summary that they were participating in rolling drag race, and that's what.
in the DIMS report, it just mentions that a drag race is this, and then they tell in their narrative what they observed, and in the observation point of their narrative, it never mentions that they were ever seen.
I don't agree. I think that it's sufficient, especially for the low burden of probable cause. Gentlemen, I'm going to find that there's probable cause to go forward with each of your cases. If I find that you participate in actions like this again, I will revoke your bond and put you in jail. Do each of you understand? Not only that, the district attorney's office has started seizing and taking cars from individuals who participate in multiple drag racing. There's a place to do it, not on 610, not on 59, not on I-10. Do you understand, each of you? Do they have licenses to drive?
They both have a valid license.
All right, you must maintain liability insurance as well. We will have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. Because you have him as a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Stoll. If he tells me he cannot get a hold of you, I will revoke your bonds and put you in jail. Do not pick up any new cases. Do each of you understand? Okay, we'll have you sign a reset. I'm gonna have you take a seat in the pew over there. Once you get the bond conditions, you sign it, at that point, you're free to go. All right? Please, gentlemen.
Judge, just to make sure the bond conditions were.
Just no racing, reckless driving. Yeah.
All right, Judge, number 7, Melendez, come on up.
Yes. Yeah.
Thanks.
Yeah. All right.
I have signal for.
That's Mr. Sigmund right here.
We'll do yours next.
That's fine, Judge. That's fine. Thank you. I appreciate it.
Yeah, for sure. What was your last name?
Slide please.
All right, Mr. Melendez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, sir.
Okay?
On August 8th, 2026, an officer was dispatched to the intersection of Fuqua Street and Sabo Road, which is a public roadway in Harris County, Texas, in reference to a traffic hazard. Upon arrival, the officer observed a silver Dodge Ram pickup truck remaining stationary in the middle of the roadway. The officer approached the vehicle and observed the driver, the defendant, to be asleep behind the wheel while the engine was still running. The officer banged on the window multiple times, but the defendant wouldn't wake up. The officer then instructed the tow truck driver, who was on scene, to unlock the door due to there being an apparent medical emergency. The tow truck driver then unlocked the door and placed the vehicle in park. The officer then began shaking and shouting at the defendant, and he eventually woke up. While speaking with the defendant, the officer detected a faint odor of alcohol emanating from his person. Field sobriety tests were then conducted with 6 out of 6 clues on the HGM, 3 out of 8 on the walking turn, and then 0 out of 4 on the one-legged stand. The DIC was read, but the defendant refused to provide a sample of breath/blood, and a blood warrant was signed and executed.
Does he have a license to drive? Please.
I'll pull it up, Judge. What is the license? He can't-
Melendez.
Yes, he does, Judge. It's in the document.
Mr. Melendez, I'm going to find that there's probable cause to go forward with your case. You just had one dismissed. I'm now requiring you to obtain an ignition interlock for your car. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you do, then I will put you in jail. There will be no more PR bonds for you. Do you understand?
Yes.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If I find that you're using, then likewise, there will be no more PR bonds for you. We are going to reset your case to give you time to hire a lawyer.
I have a lawyer.
Who?
It's Steven Stewart. He said he's gonna be here in 30 minutes. I don't know when he's done.
Okay, so I don't see any paperwork. Do you?
I don't see that.
Okay, so what we'll do is we'll get everything ready. We'll have the reset done. We'll have your bond conditions done. And then when he comes, then he can pick a date. Okay, please.
Judge, counsel has a video.
Yeah, it's okay. Yeah, let's, come on up.
Thanks, Judge. I appreciate it. I got a
Hey.
assignment.
So,
Derek Johnson.
can you file the guardian interlock paperwork with Homeboy?
Yes, Judge, it's there.
Got it. Okay. Derek Johnson, come up.
John Burnett having picked up a felony. So
That's no bueno. Come up, Mr. Johnson. What is the one thing we told you not to do? Pick up a new case. And now you've picked up a felony violation of protection. What happened in the case, please, in the felony one?
Yes, Judge. On July 30th, 2026, an officer was dispatched to a disturbance call. The officers arrived and observed the defendant and the complaining witness through an upstairs window. The defendant ran downstairs and attempted to run out of the back of the house. The officers approached. The complaining witness stated the defendant had hopped the fence. The officers detained the defendant from where he was hiding in a bush. The complaining witness stated she came home around 1 a.m. She was showering. The defendant came to the residence and accused her of being unfaithful. The defendant slapped the complaining witness, causing pain. The complaining witness called the report, but officers did not arrive until later. The defendant was already caught.
Okay, Mr. Johnson. I'm revoking your bond. You're going to jail today. And I'm going to tell you now, I'm going to put a GPS monitor prior to your release. If you get out, if you go anywhere near this house or person, I can have a hearing to hold you at 0 bond. And I will do it in a heartbeat to protect every person in my community. You're not to go within 1,000 feet of where she lives, works, or breathes. Do you understand? Okay, it goes with you. Set it at 5,001. Okay,
Yeah.
and I signed your motion already.
Thanks, Judge.
All right, Judge, the next one is top of 8, Molina.
All right, good morning, Miss Molina. Ma'am, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, sir.
Okay.
On August 8th, 2026, an officer was dispatched at 3401 Garrett Street, which is a public roadway in Harris County, Texas, in reference to a crash major. Upon arrival, the officer made contact with the defendant. While speaking with the defendant, the officer observed her to have glossy eyes and there was an odor of alcohol emanating from her breath. The officer also observed a 1.5 liter buzzball laying on the ground. The officer detained the defendant and then spoke with the occupant of the other vehicle, who hereinafter is the witness. The witness said the defendant hit her vehicle and she had a baby inside the vehicle and failed to stop to exchange information. The witness said she followed the defendant and observed her throw the buzzball out the window. The defendant admitted to consuming 3 mixed drinks prior to operating the vehicle. Field sobriety tests were then conducted with 6 out of 6 clues on the HDN, 4 out of 8 on walk and turn, and then 2 out of 4 on the one-legged stand. The DIC was read and the defendant consented to breath tests, with the results being a 0.161, 0.157.
So she had alcohol in the car is the allegation, right?
Yes, the witness saw her throw the buzzball outside the window.
And Judge, I do want to point out that she's also 20 years old.
Ms. Molina, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you now not to drive any vehicle that's not equipped with an ignition interlock on it. I send notice to DPS in Austin. Every police officer in the state will know if you're pulled over, you're driving a car, and that car doesn't have an interlock, they're going to take you to jail. Do you understand? Just don't do it. Don't consume alcohol. Don't use illegal drugs. I'm telling you that you're going to get tested. It's not a matter of if, it's a matter of when. If you test positive for anything illegal, including marijuana, THC, gummies, vapes, it's just not going to go well between us. You understand? How do you support yourself? How do you support yourself? Do you have the ability to hire a lawyer?
No.
What do you do for a living?
I work at a hair salon as a receptionist.
Okay. What kind of money do you make a month?
13 an hour at the moment.
Okay. Deputy, do you mind giving her an application? We're going to give you an application for a court-appointed lawyer. I need you to fill it out fully, truthfully, because you're going to swear to it, and then I'll take a look to see whether you qualify. And having you sign a reset, you'll get with Veronica for your bond conditions, and then we'll have you take a seat in the queue. Please, ma'am.
This way. All right, bottom of 11, Rivas.
Good morning, Ms. Rivas.
Good morning.
Ma'am, you're charged with theft. Again, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, sir. On August 6th, 2026, an officer was dispatched at 36 Farm to Market, 1960 Road West, which is Kroger in Harris County, Texas, in reference to a theft. Upon arrival, the officer met with the complaining witness, who's the manager, who stated the defendant grabbed multiple items, including alcohol, jelly, and cat treats, and then exited the store without making any attempt to render payment for the items. The complaining witness confronted the defendant and confirmed the items were stolen. The defendant was then detained until the officers arrived. Total value of the stolen merchandise was $37.23, and the defendant was ID'd by her Texas driver's license.
And Ms. Rivas, I'm going to find that there's probable cause to go forward with your case. You are not allowed to go back to any Kroger whatsoever for any reason. Do you understand?
Yes.
If you violate this condition, I will revoke your bond and put you in jail. Doesn't matter how little, how minute you may think it is, just don't pick up any new cases. Do you understand? And do not violate these conditions. Do you have the ability to hire a lawyer? Deputy will give you an application. I need you to fill it out and we'll take a look to see whether you qualify. Can you file, please? No going to any Kroger. All right, please, ma'am.
Right this way.
Hang on.
All right, Judge, next is page 14, Scroggin, come on up.
Good morning, Ms. Scroggins.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On August 7th, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when they observed a gray Nissan Pathfinder going 85 miles per hour in a 65 mile per hour zone. The vehicle was also failing to maintain a single lane. A traffic stop was conducted and the officer made contact with the driver and the defendant. While speaking with the defendant, the officer observed her to have glossy eyes, slurred speech, and there was a strong odor of alcohol emitting from her person. The defendant admitted to consuming 2 beers prior to operating the vehicle. Field sobriety tests were then conducted with 4 out of 6 clues on the HGN, 2 out of 8 on walk and turn, and 2 out of 4 on the one-legged stand. The DIC was read, but the defendant refused to consent to breath/blood. The blood warrant was then signed and executed. The officer also located a marijuana pen inside the defendant's vehicle during the inventory search.
She have any prior DWIs? Do you mind looking? And then does she have a
She
license?
has no criminal history, Judge.
Okay, like
What's the defendant's last name?
Scroggins. Ms. Scroggins, I'm going to find that there's probable cause to go forward with your case. You're ordered not to consume alcohol or illegal drugs, including marijuana or vape pens. You will be tested. If you test positive for either, I will revoke your bond and put you in jail. You understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance. You must also maintain car insurance. If you don't have it, then likewise do not drive. How old are you, ma'am?
24.
Do you have the ability to hire a lawyer?
Yes, sir. I have an attorney, but he said he was supposed to be over here.
Who is it?
Greg Ramsey.
Okay, I don't see any documents filed on their behalf. So let's do this. I'll have you sign a reset. We'll get you done with all the paperwork. We'll let you wait a while to see if they show up. If they do, great. If not, then we'll give you time to go hire them. Okay? Yes, ma'am, please.
Right this way. All right, Judge, next is bottom of 16, Tran. All right, Judge, page 17, Turner.
Good morning, Mr. Turner. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, sir. On August 7th, 2026, an officer was conducting a routine traffic patrol in Harris County, Texas, when they observed a black Chevrolet Cruze run a stop sign at the intersection of Staple Street and Reddish Street. A traffic stop was conducted and the officer made contact with the driver, the defendant. The defendant immediately informed the officers that he had a firearm within reach while he kept his hands outside of the driver's side window. The defendant was then told to exit the vehicle and he complied. The officers then searched the vehicle and located an unholstered AR-15 pistol on the driver's side floorboard. The officer also located 2.09 grams of marijuana inside the vehicle. The defendant was detained without incident. The defendant's dog, which was inside the vehicle, and vehicle were released to a family member on scene per his request.
All right, Mr. Turner, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons whatsoever. Do you understand? Don't pick up any new cases. Don't endanger my city. It's just not going to go well for you if you do. How old are you, sir? Do you have the ability to hire a lawyer? We will give you time. I'm gonna have you sign a reset. We'll have you take a seat while we get the bond conditions. Once you sign them, at that point, you'll be free to go. Okay? Please. No weapons, guys, please.
Yes, sir, got it.
All right, top of 18, Wilkerson.
Good morning, Mr. Wilkerson. Sir, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On August 7, 2026, an officer was dispatched to 11111 West Montgomery Road, which is an apartment complex in Harris County, Texas, in reference to an assault. Upon arrival, the officer made contact with the complaining witness who stated the defendant and his girlfriend were arguing in their apartment and creating a disturbance. The complaining witness stated she, her friend, and her neighbor all went to the defendant's door and started banging on it in order to get them to stop. The complaining witness stated the defendant and his girlfriend then exited the apartment and physical altercation ensued between the complaining witness and the girlfriend. During this altercation, the defendant entered and struck the complaining witness on the left side of her face with a closed fist, causing pain. The officer observed visible injuries on the complaining witness, including a large laceration on her eyelid and significant bruising. Both witnesses confirmed the complaining witness's story. The officer then spoke to the defendant and his girlfriend, and they provided inconsistent statements. The defendant was taken into custody without incident.
Mr. Wilkerson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person and not to be in possession of any weapons. I'm also ordering you not to go within 200 feet of where they live or where they work. If you violate this agreement, I will put you in jail. There will be no more PR bonds for you. Do you understand, sir? You have the ability to hire a lawyer.
No, sir.
How do you support yourself? What do you do for a living? Okay. What kind of money do you make a month?
I'll make money, bro.
So how much money do you make a month? You said you make $19 an hour? You make around $3,000 a month. Who do you live with? Okay, I'm going to give you the opportunity to go hire a lawyer. It's time. So what I'm going to have you do is I'm going to have you sign a reset. I will have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. I don't know who you have in this life, Mr. Wilkerson, but if I make your bond $10, $20, $30, $50,000 and you don't have anyone to pony up that kind of money, you'll be stuck with me for a long time. There are no mistakes in this life. There are choices. You either make a good choice or you make a bad choice. I don't want you to go anywhere near this complaining witness. You understand? Okay, come on.
Mr. Wilkins, there's no contact. Go ahead and sign for the reset.
No contact, no weapons, no going within 200 feet of where she lives or works. Please.
Page 16, Fran, come on up.
How many more we got?
Just the last one.
Come on, Fran.
Another without an attorney.
Do what?
With one more with an attorney.
Okay. All right. Do you speak English, sir?
Yes, sir.
Mr. Tran, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir. On August 9, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when they observed a black Lexus with no headlights on, and this was during the nighttime. The officer attempted to conduct a traffic stop with the emergency lights activated, but the vehicle refused to pull over and continued to drive northbound. The vehicle eventually pulled into an apartment complex, passed up on multiple safe points to pull over and made 2 turns, and the officer was able to detain the driver, the defendant. The officer observed the defendant to have an apartment access card in his hands when he detained him. The officer also observed the defendant to have glossy eyes, unsteady balance, and there was an odor of alcohol emitting from his person, though the officer didn't think he lost use of his normal faculties.
Wow. 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 So how far was the alleged fleet?
I believe it's 0.3 miles, Judge. Actually, they don't even clarify it in the notes. It just says he passed up on multiple safe points, and he made 2 turns. I agree, Judge. That smells fishy.
That's funny. Let's pull up the code. Let's see what it says. Thank you for your honesty, though. All right, let's pull it up. So a person commits an offense if the person operates a motor vehicle and willfully fails or refuses to bring the vehicle to a stop, or flees or attempts to elude a pursuing police vehicle when given a visual or audible signal to bring the vehicle to a stop. Do we know, was there a visual,
The emergency lights were on and, the sound was on.
okay, I mean, distance is not a factor as far as penal code is concerned. It's whether you stop or whether you don't, right? So,
I also want to clarify, he turned on his hazard lights as they were pulling him over, so he might have just been trying to signal to them that he was trying to find a safe spot in order to pull over.
but you said that there were 2 other locations that he could, right?
Yes,
That's what the officer
Yeah,
said.
he turned
I mean,
on-
yeah, it meets it for now. I mean, it may not be beyond a reasonable doubt, but for purposes of probable cause, I think that there's enough to go forward. Does Mr. Tran have a license to drive?
Yes, he did.
Mr. Tran, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. You understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance. Those are also conditions for you. Don't worry about filing it. I'm going to monitor him because I don't want to make sure he's not consuming. How old are you, sir?
24.
How do you support yourself?
I work as a server at a restaurant.
Do you have the ability to hire a lawyer?
No, sir.
Okay, deputy, do you mind giving me an application? I'll give you an application. I need to know everything about you, how much money you make, where you live, what kind of cars you have, and then I'll take a look to see whether you qualify. Do not leave until you sign the bond conditions, and then we'll have you sign a receipt. Okay, please. Eric,
Morning, Judge.
do I know you?
It's been a minute.
I know. How are you? Great to see you, man. What's new?
I got Mr. Romo.
Romo.
Docket.
Jail or bond?
Bonds.
Is he here?
It's my understanding he was sent to get a drug test.
So he failed to show.
He failed to do his drug test last week. He had a BVR. He showed up to court today and was sent to
Okay,
test today.
Romo. So we're in trial now.
Yes, that's why I just wanted to say hi.
Yeah, so you know the drill. Admonish him and tell him if he ever misses again, he will go to jail. I'm not going to do this again. It depends on what happens now, obviously. So I guess just keep me in the loop, and we'll go from there. Yeah, for sure. You too. Mr. Mills.
Hey, Judge, I know you all are in trial. I wanted to briefly pop on for that case. I'll give you the cause number that I appeared on a couple of days ago. I do want motion to withdraw signed. So
You do want to withdraw?
yes.
Okay, I don't think he's here. So why don't we
Okay.
do this? File your motions. I'll put it on for Monday. Just chat Victoria or any day next week, whatever's best for you. But I don't want to grant it now and have him in jail without a lawyer. You know what I mean?
Okay.
I'll grant
Okay,
it.
the motions are filed, so Monday's fine.
So just email Victoria so we can put it on the docket. Do you mind?
Okay, fine.
Okay, he wants to withdraw from 2 cases
One from like yesterday.
or 2 days ago, something like that. Yeah. So we'll just put it on for whatever day next week. I don't care.
Okay.
Okay. Are there any BVRs that we should take care of now?
William, I think it's getting Sanchez.
Well, thank you, Judge. I just shoot her an email.
Okay, thanks, Mr. Mills. Take care,
Thank
man.
you, Judge.
Council wanted to approach for a reinstatement.
Come on.
Okay.
Judge, I
We're
just-
gonna start trial. I was trying to-
Mr.
Yeah.
Sanchez, it's a BVR, it's a one, positive on call. Guillermo Sanchez, he was sent across the street, they wrote this morning. You know, I asked the court to try and punish him.
Veronica,
He's still current in custody.
I know, but on Mr. Sanchez, can you, let's amend the bond conditions, put a scram on his ankle now? So we know he's not, and any further violations,
Judge, if I may, he had to set a job that.
he has an unlawful restraint, an interference, and a felony assault. He tests positive for alcohol. He's lucky he's not going into jail. I don't give a rat's behind. I told him not to drink. He's got a bond violation. He's either going into jail or he gets a scram. Really, if we enable, what happens?
Judge, I'm not
Right.
challenging the court, I'm just saying that his new job is very labor intensive, but I just want to make sure that the scram stuff, would hinder him from doing it. If it's not, I don't mind. Okay, then that's.
Actions have consequences.
So, Judge.
So I hope I don't know. Tell him not to violate again, otherwise it's not going to go well between us, okay?
For the scram, can we,
Yeah, I'll pay for it. Don't worry.
thank you.
Yeah, okay.
That is used.
Yeah.
It might probably be sued.
Well, once he's, yeah, and assuming he doesn't test positive again. I don't know about that. We sent him a test, so hopefully he's,
If he does. would you like-
then we'll have, no, then we'll have to have a whole other hearing.
Okay.
Yeah. Okay,
All
right. Come on up.
Oh, you know, the case number?
What is it?
It's 260.
Okay,
697.
on Allen?
Yes, sir.
Okay,
You know, we approached yesterday to set it for trial. We got his trial date for July 6th.
he didn't show up.
Quickly yesterday, I was there.
Judge, he did show up, you wanted to go to the side, the one that said.
This is the one that just left.
Right, but he had gotten a trial date from the long night, and he wanted to know, so I thought it was MIA that he was gone. I never got him to sign a reset or anything, I had no idea it was being set.
Is the defendant here now?
No, yeah.
I'm not gonna, when he gets here to sign the reset, then I'll reinstate it. So if you bring him next week, then I'll reinstate it for you. Okay? All right. Craig,
Sir, may I approach?
please. Yeah, we're about to bring a jury in, so
Yes, sir.
deputy, after this, we need to get the jury.
I'm here on Angel Melendez. I know that he had been called up before, but I'm gonna be his attorney. I was just gonna see if I can make a quick argument on PC. And have him assigned to a court within interlock, he's not gonna be driving.
Well, I don't know that, but okay, go for it.
So, with the PC, basically, it's that he was, stopped eastbound on Euclid and Beamer.
He stopped in a moving lane of traffic.
Facing east, yes, sir. And so my argument is that that's not inherently an illegal activity that should merit the attention of.
He stopped in a moving lane of traffic. He's impeding traffic. It's obstruction of a highway.
Maybe, they didn't allege it.
No.
The only thing that.
Yeah, they did.
alleged Is they said that there was a record driver who they had talked to, but they didn't allege that that was a reliable person, which is what they're supposed to be. They didn't allege who that person is. And so they're relying upon some unknown third party, even in the danger report, as far as any indication that the vehicle was, was or was not in part.
Did the officer see him as such?
Judge, they saw the car remain stationary, they walked up to the vehicle and saw him asleep behind the.
Yeah, I think there's PC. Yeah, and I nevertheless, he still has a car. I want him to have an interlock on.
He's gonna be in Waco, Your Honor. So he has a job that's in Waco, and so the car's gonna remain here in Houston, so he won't be able.
But how do I know that? Do you know how many people ask me for a portable device and we still catch them driving and we put them in jail anyways?
I get it, but if he's on the portable, he's gonna be blowing 3 times a day, and the car is gonna be, we can have him sign a no driving affidavit, Your Honor, that's fine. We can do that. The
If he
problem
still
is
has
if we have the
access.
interlock, what'll happen is pretrial servicing is gonna get angry because he's never gonna blow into it because it's in Houston. And
And then he gets a bond violation.
Right, so it's impossible for him to have the car. If the car is in his parents' name, he doesn't have access to his car when he's in Waco. They were letting him use the car while he's.
Bring me proof of what he's doing in Waco. Bring me proof the car's not in the parent's name, and then we'll talk. But I'm not gonna take his word for it. Oh, hey, I'm not gonna drive because we
Have
see
you
way
done
too
today
much.
during break at the trial?
Sure, of course. Yeah, anytime.
Yes, sir.
Yeah.
I didn't want to delay what y'all are trying. to
Don't
do.
worry about it.
Yes, sir.
You're good. Okay,
He's
yeah,
supposed to
take your
leave
time.
for work.
We'll be here for a while. Yeah. Okay, let's get the jury. Guys, we are in jury trial. Please do not talk. If you have to do anything, go outside. Okay, let's get the jury. Yeah, yeah.
No, it's in the. Okay. So then if you need a Turner.
Mhm, yeah.
Oh, what's your name? Oh, like, Joe. Mr. Turner says that.
No weapons, Matt. Sorry. Yep, let's go.
All right.
Stay. You ready to call your next witness? Ready?
Yes, right.
All right, everybody, please be seated. State, do you want to call your next witness?
Caitlin Falls West to the stand.
Okay.
Your Honor, this witness has not been sworn in.
All right, if you mind coming up to the witness stand, please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, please take a seat. Please testify loudly, clearly. If you hear the word objection, stop. Once we've addressed it, at that point, you may continue. Okay? All right.
Please say your full name and introduce yourself to the jury.
Sure, my name is Caitlin Falkers Orlando. That's spelled Aitlyn. Last name PALMQUISP-LAND.
And what is your occupation?
I'm a toxicologist one with the Harris County Institute of Forensic Science.
And how long have you been employed?
I've been at the Institute for almost 5 years now.
Can you explain to us what is toxicology?
Sure, toxicology is the study of drugs, alcohol, and other poisons in body fluids, be like things like blood or urine, and how they relate to different crimes or causes of death.
And can you tell us or explain to us what are your duties?
Sure, so as an analyst, I can prepare samples for the analysis of drugs and alcohol. I can review the data associated with those analyses. I can technically review other analysts' work, and I can perform administrative review of reports. I also can provide testimony when requested.
And what is your educational background?
I have a Bachelor of Science in Forensic Chemistry from Towson University and a PhD in Forensic Science from San Luis State University.
What's your, are you certified or licensed in toxicology?
Yes, I have a license with the Texas Forensic Science Commission as a toxicology analyst, general non-interpretive, and I am certified by the American Board of Forensic Toxicology as a fellow.
What specific trainings have you received in the field of alcohol analysis?
At the Institute, we have a training program where each topic is broken down into a module. So for alcohol, there'd be a module on alcohol, which would include reading relevant literature. This could be things like standard operating procedures, textbooks, things like that. We also have to observe a qualified analyst perform a task, and then I will perform that task myself under supervision, and then unsupervised to ensure competency. I also have to participate in a written exam, an oral exam, and a mock.
Do you belong to any professional organization?
Yes, I am a member of the Society of Forensic Toxicologists, the American Academy of Forensic Sciences, and the International Association of Forensic Toxicology.
And have you written any publication in the field of forensic toxicology?
Yes, I have.
Can you tell us a little bit about it?
Oh, sure. I have several first author publications that came from my graduate work at San Luis State University. And I've worked on a couple of other publications with other people in the field dealing with various topics, analytical methods, on other findings.
Do you analyze the WI cases as part of your regular duties?
Yes, I do.
And then, have you testified as an expert before regarding this?
Yes, I have.
Could you tell us approximately how many times?
I believe this will be my 7th time.
What is the accreditation that your laboratory holds?
We're accredited by the American National Standards Institute, National Accreditation Board, to standards of ISO 17025, and the American Board of Forensic Toxicology. We are also accredited by the Texas Forensic Association.
There's a couple of those exhibits.
Sure, of course.
If you want, we can you see the numbers and everything?
Yes,
Do you recognize State's Exhibit 4?
yes, this would be a picture that one of our toxicology technicians took during the evidence receiving process that was included in the case file.
And can you please read us the number for the case?
The IFS number, which is tied to the Institute, is IFS 25-11065.
Is this one of the packets that you received in your lab to analyze?
Yes, this would have been submitted to the laboratory.
Can you tell us what State's Exhibit 5 is?
So this is a picture of the blood tubes that were inside of that manila envelope. When our evidence technicians receive evidence in toxicology, they will take pictures at every step of the unpackaging process while they're reviewing the submission form and the evidence received. And this is one of the steps of that unpackaging process.
And why do they do that?
To document the evidence under the condition that it was received in toxicology.
And can you tell us what you see in State's Exhibit 6?
And these would be the blood tubes that were inside the bubble wrap of that previous.
And do you see any writings on them?
Yes.
What are those writings usually tell you?
It depends. Sometimes there's names, dates, times, case numbers written on there. I believe that would be the agent's number associated with the police agency.
And what is the purpose for that?
That would just tie their case to our case. We ultimately put our own identifying information on the blood tubes, so that everything is tracked within our system.
Do you know by looking at the number, if this is the if you analyze the blood that's contained in these tubes?
Yes, but I would recognize it better if I would be able to see our label and barcode.
Sure. Judge David?
Yes.
Showing you what's been pre-marked as State Exhibit 9. Do you recognize this?
Yes, that is the toxicology lab report.
And how do you know? How do you recognize?
So our toxicology lab report has a header at the top with our institute's information on it, an address and phone number. It says toxicology report on it. It also lists the case number associated with the blood vials, all the submission information, and then my name appears on the report as the analyst who performed alcohol testing.
Has it been changed or altered in any way?
No, it doesn't look like it.
Let's investigate that, on it.
Please.
And then Exhibit 9, defense.
All right, it'll be admitted. Can you maybe zoom in a little bit?
Yes, Judge.
It's really hard to see.
Just seeing it so the everything we're talking about.
Okay,
Just
yeah.
the number. So could you tell us if this number corresponds with the blood tubes that you were just seeing in State Exhibit 6?
Yes, so they have a laboratory case number that is at IFS 25-11065. During the evidence and packaging process, while those technicians are taking photographs, they will also itemize the evidence. So these blood tubes would have their own item number as well, which is paired with a barcode, and that barcode is printed out and usually affixed to those blood tubes. And that's the way I personally keep track of them when I handle those.
So did you analyze the blood in those tubes that you see?
I analyzed the blood in one of the tubes.
I'm sorry if I missed, if you already explained this, but how are the blood vials tracked once your lab takes custody of them?
Sure, just to back up a little bit, so when evidence comes into the laboratory, it's brought by usually law enforcement to our evidence intake section. They will review the submission form and enter the information into our laboratory information management system. This is our database that tracks all of the evidence. From there, they will assign it that laboratory case number. They will then bring the evidence to toxicology. The toxicology technician will then receive that evidence, take photographs at every step of the unpackaging process. They will make sure that the information on the submission form matches that of the evidence packaging. They will itemize the evidence, the items of evidence within that package. They will seal it and place that evidence into transfer before it's ready for testing.
When you say they put it in the storage, how is the evidence stored?
The evidence is stored under refrigeration, and when the technician places it in storage, with the evidence item number, like I said earlier, a barcode is generated, and so these barcodes can be scanned to track in custody, which is the evidence is lifetime throughout the lab, so when they put the evidence into storage, they can scan it into that location. If somebody else were to take it out of storage, they can scan it into their custody. So that's how we found where the evidence is living throughout the lab.
Does anyone else that works outside the lab can just walk in and get access to these samples?
I'm sorry, say that again.
Can anybody who is not working in that lab or has no business there walk in and get access to these tubes, to these samples?
No, our building is a secure facility. We have to have badge access to enter. Our floors and our elevator are even secure and require badge access. And then only toxicology personnel and a couple of other individuals are allowed to be in the laboratory.
What type of blood vials are usually submitted to your lab?
We usually receive 10 milliliter gray top blood tubes.
Why is it important or significant to have the gray top tubes?
The gray top tubes have potassium oxalate and sodium fluoride, which are an anticoagulant and preservative in them.
Why wouldn't you want the blood to clot?
Clotting can interfere with our ability to accurately determine the amount of alcohol that's in the sample based on that chemical composition or physical composition of the blood.
Earlier, we had testimony from our phlebotomist and the officer that the blood vials were inverted. A minimum of 8 to 10 times. Why is that important? If you can tell us, please.
I'm not familiar with the phlebotomy procedures, but I would assume that the inversion.
Sustained.
Sure. What are the potential effects of the blood not mixing with the two chemicals that you just explained?
If the blood's not sufficiently mixed with those preservative or the anticoagulant, it could clot.
When looking at State's Exhibit 6, do you see any clotting?
No, but looking at a photograph wouldn't really tell me if it's clots or not.
In your report and your case file, do you see any evidence that there was anything wrong with this sample, including clotting?
No, these are things that I would recognize and document during the analysis process. All the samples are handled individually. There are rocks within the laboratory to ensure that everything's mixed properly for our testing. So anything out of the ordinary would be documented on a lab notes, and I did not have any documentation.
How many times do you have to test the blood that you receive?
For alcohol testing, every sample has to be screened at least once. If the result is positive, it will be ran a second time for confirmation. These two tests have to be within 5% of each other. In this case, they were, so no further testing was needed.
Can you briefly tell us the process that you use to measure the amount of ethanol in the blood?
Yes, we use a technique called headspace gas chromatography flame ionization detection.
So can you tell us what that means and how is that done?
Sure. So it's a 3-step process. The headspace is portion 1, gas chromatography portion 2, and flame ionization detection is portion 3. So first, as the analyst, I will take a portion of the blood and put it into the headspace vial. This is a vial about this big, just a glass container, which will be capped and sealed. This will be placed on the headspace portion of the instrument where the vial is agitated and heated. The purpose of this is to heat the alcohols that are within that blood sample so that they evaporate into the air above the blood sample. This is known as the headspace. So a portion of that headspace will then be injected into the gas chromatograph. In the gas chromatograph, the alcohols will then separate as a function of time so that each alcohol exits that portion of the instrument individually. It will then enter the flame ionization detector where the alcohols are burned. Essentially, the greater the burn or the greater the flame, the more alcohol is present in the sample. And so I like to kind of tell people this is like putting gasoline on a fire. The more gasoline you add to the fire, the bigger your flame is going to be. So that's kind of how we're able to relate how much ethanol is in a sample to the response that's generated from the instrument.
And just to be sure, when you say ethanol, what would be the regular person's name for that?
Sure, ethanol is drinking alcohol.
So before doing the testing, do you have any measurements that you take to make sure that all the instruments are functioning properly?
Yes, we have a daily maintenance checklist that's performed. This is to ensure that the instrument has all the proper materials that are needed to perform the testing. And then every day, a series of what we call calibrators and controls are run. These are samples of known amounts that we're using to confirm that everything is working properly, that our ability to quantitate or get a number, numerical values for the concentrations is accurate and working applicable to case studies.
Is the scientist behind this process generally accepted in the field and within the relevant scientific community?
Yes, it is.
Does this process in any way affect the level of ethanol that's present or altered?
No, it's not.
How does your lab ensure that there is quality control as a result of the results?
Sure. So, like I mentioned, we run a series of controls. These are samples of known concentrations. We run them at the beginning of the run, but we also run them throughout the batch, which is a batch, meaning a batch of samples, to ensure that the run is, or the instrument is functioning properly over the course of that run. So this is something we can just use to validate that everything's working properly. Additionally, all of the work that I do is reviewed by our analysts from the batch level, so making sure technically everything I reviewed was correct and there were no mistakes or errors made. Additionally, then cases are reviewed administratively and with a limited technical review, which is then followed by an interpretive review by our senior staff.
Did the quality checks work in this case?
Yes, they did.
Were you able to determine the level of ethanol in this case using the scientifically accepted protocols that you just described?
Yes.
And do you recognize this? I mean, yeah, you that's the one that. Oh, you can see it. What were the results of your analysis in this case?
Ethanol was detected at a concentration of 0.256 plus or minus 0.031 grams per 100 milliliters. And acetone, isopropanol, and methanol were all non-detected.
What is the plus and minus number for?
So that is what we refer to as measurement uncertainty. It's just the inherent variability that occurs when taking measurements. So you can think of this like stepping on a scale. If you step on the scale 3 times, you might weigh 149 pounds, 150 pounds, and then 151 pounds. So you could express your weight as 150 pounds plus or minus 1 pound. And that's how we will generate any numerical values within the laboratory to capture that variability.
So if you had to put that in effect, where would you put that number between what to what?
I didn't do that calculation, but if you were to subtract
Are you familiar with the way that they do the subtraction?
Yeah, you would just take the 0.256 minus 0.031. That would be your lower limit. And then you would add it to get the upper limit. And statistically, the true value falls within that range.
Would that number, is that number above the legal limit, which is 0.08?
Yes, that number is above. However, I will preface with that number was generated at the time of testing, not the time of trip.
And is that also above 0.15?
Yes, it is.
And that's at the time of testing also.
Yes, correct.
So to the best of your knowledge and experience, was this test calculated properly and performed properly?
Yes, it was.
Does anyone else review this data prior to reporting?
Yes, so I previously talked about, we have a technical review on the batch level. There's then a limited technical review and administrative review for the case level, so just all the information for one case. And then there's a final interpretive review where senior staff will look at the case to make sure it meets toxicological standards.
So you talk about the time of that's the ethanol at the time of testing. Does the ethanol level change from the time of testing to the time of blood draw?
It could.
Would you be able to tell us, would that be a significant change?
I would leave those questions for the interpretive reviewer. I can't speak to those types of things based on the license that I have.
Gotcha. I passed the witness.
Okay, are you ready?
Yes, good morning, Ms. Thompson. You said that you are a toxicologist,
Yes,
and so you prepare samples, review data, and other analysts' work.
yes, that's correct.
Okay. You did not draw the blood in the case.
No, I did not.
You cannot testify from personal knowledge that the blood was drawn correctly.
No, I cannot.
You relied on the documentation that was provided to you by everyone that handled the blood before you.
Correct. I don't know what happens to the blood before it enters the institute.
Okay. So if a sample was mislabeled before arriving at the lab, you would have no personal knowledge of that.
No, I would.
So blood samples should be stored according to laboratory protocol.
Yes.
Can excessive heat affect biological samples?
Yes, it can.
So you rely on everyone that handled the blood before you to properly transport and store the sample.
Yes, we have recommendations on our website for how samples should be stored, but ultimately how they're followed is, we don't know.
So you cannot personally verify the temperature throughout transportation,
No, I cannot.
or whether the person that handled this before you handled it according to protocol.
No, I cannot.
So the gas chromatograph is the machine that runs this test.
Yes, that's part of it, yes.
Okay. It runs multiple samples in a sequence,
Yes,
and samples are not run individually, are they?
what do you mean by that?
There are multiple samples in a batch.
Yes, yes.
So that means, and I guess just to clarify, that means that samples of different people are put into the machine at one time.
Yes, so I will have multiple samples on my batch, kind of like a batch of cookies where you put multiple cookies on a tray. To cook them all at the same time. And we enter, or I will enter the name of the sample with its location on the instrument so that the data is generated for the correct sample. This sequence is also reviewed before and after testing by qualified analysts.
How many samples do you usually run at a time?
It could be anywhere from 70 to 100.
Where in the sequence was Ms. Lovey's sample?
I'm sorry, can you repeat the question?
Where in the sequence was Ms. Lovey's sample?
Mayor of minutes.
If you don't know.
Yeah, I don't know. It would have been somewhere between 20 and 140.
And is the gold standard to run a blank or a negative sample in between each sample?
No, we don't do that.
But what is the purpose of running a blank or a control sample?
Well, blank and a control is different. So a blank would be a sample that has nothing in it. We will run blanks to ensure that nothing has contaminated the instrument. So we do this by running what's called a negative control at the beginning and at the end of to ensure that no contamination has occurred throughout the run. And then the positive controls have the known amounts of ethanol in them so that we can make sure that they are being accurately quantified throughout the run.
And the purpose of that process is to ensure there's no carryover from a prior sample?
It can be.
Were all QC samples within acceptable limits?
Yes, they were.
Was any carryover detected?
No, we run a negative control after our highest calibrator. This calibrator is at 0.5 grams per 100 milliliters of ethanol. We run the negative control after that to ensure that day of there's no carryover from any sample over that amount. Carryover meaning we're able to detect the same thing in the next stage.
Did any sample in this batch show quality control?
No, they did not.
If alcohol concentration changes continuously.
In the blood tube or in the body,
In the body.
yes, but that would be a better question for or details about that type of question would be better suited for the interpreter reviewer.
You did not stop Ms. Levy, did you?
No, I did not.
You did not observe her driving, did you?
No, I did not.
Did you administer any field sobriety tests?
No, I did not.
Had you ever met Ms. Levy at all?
No, I have not.
So your involvement was limited to analyzing the vitals of blood, basically.
Yes.
Did you observe her speech or anything?
No.
And so your opinion is only limited to the blood sample.
Yes.
And it only tells us what the VAC was at the time of the testing.
Yes, that's correct.
What was Ms. Levy's VAC while she was driving?
That I don't.
No further questions.
Okay. Anything further?
Just a couple questions. Will reviewing your notes
I'm sorry.
refresh?
Say again.
Will reviewing your notes refresh your recollection as to where Ms. Levy's vial was located within your badge of testing?
Potentially, but I may not have that information with me.
Um,
So I'd be happy to check.
do you wanna check and see?
So I actually do have it. For the first test, it was vial number 94 out of 142. And for test number 2, it was vial 63 out of 140.
Is there any significance to that number? Would that affect the result of testing?
No, that's just the location on the instrument that it was analyzed.
Do you ever meet the defendants in any case that you receive?
No.
That's the difference.
Okay. Anything further? Okay. May this witness be excused?
Yes, Judge.
Okay. All right. Thank you for your testimony. Be safe. And State, you want to call your next witness?
Yes, Judge. State Clause Jason Gaslin.
All right, if you want to come up to the witness stand, sir. Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, come on, come take a seat. Please testify loudly, clearly. If you hear the word objection, stop until we've addressed it, and then you may continue. Okay, please. Okay, your witness.
Good morning. Will you please state your name for the record and introduce yourself to the jury?
Yes, my name is Jason Gaswin, and that's GASWINT.
How are you employed?
I am a toxicology student at the Harris County Institute of Forensic Science.
What are some of your duties at your prison?
Some of my duties include doing technical reviews of batch work and reviewing cases. I also perform the final review for ethanol-only cases, and I provide court testimony when requested.
What could you tell us what is the purpose behind that?
Behind,
What you do? What's the purpose of reviewing?
the review process is just to ensure we're putting out good, accurate work, making sure that everything that we are releasing is representative of the testing.
Can you tell us a little bit about your education and the process that qualifies you to perform your duties?
Yes, I have a bachelor's of science in wildlife biology with a minor in chemistry from Southwest Texas State University and a master's of science in health services research from Texas State University. The training for my job includes for ethanol only review. I was given a list of materials to read, and in order to test my understanding of those materials, I needed to pass a written and oral exam in addition to a mock trial.
Have you been qualified specifically in the effects of alcohol on human body?
Yes,
Did any of your trainings that you spoke about earlier focus on effects of alcohol on human body?
yes,
Do you belong to a professional organization?
yes, the Society of Forensic Toxicologists.
And are you board certified or otherwise licensed?
Yes, I am board certified by the American Board of Forensic Toxicology, and I am licensed by the state of Texas as a general interpreter.
How many times have you been certified?
As a witness,
Yes.
I believe it's around 37 times.
Did your testimony include on those cases the effects of alcohol on the human body?
Some of them, yes.
What was your role in this case?
I was the interpretive reviewer.
Can you explain to us what ethanol is?
Sure. Ethanol is the alcohol commonly found in alcoholic beverages. It is a central nervous system depressant, meaning that it reduces the activity of the brain and spinal cord.
And other than that, can you tell us what effects does it have on human body?
Sure. Ethanol is a concentration dependent depressant, meaning that at lower concentrations, it's going to affect you differently at higher concentrations. At lower concentrations, individuals become more talkative, have more self-confidence, and some slow information processing. As the blood alcohol concentration increases, visual acuity and peripheral vision is reduced, and individuals will have trouble with judgment, memory, and balance. And at high blood alcohol concentrations, individuals can become dizzy, confused, and they may stagger when they walk.
Can you tell us how do these effects relate to someone's ability to drive?
Yes, so driving is a divided attention task, meaning that it takes more brain power to do that than simple tasks. So ethanol reduces the ability to drive by increasing risk taking, slowed information processing, and impaired judgment. So basically what's happening is all of the information that's coming in off the road is your brain is having trouble processing all of that information and then making the correct decision for your reaction.
So on your screen here, we have states exhibit 9. Could you tell us what the ethanol or the blood alcohol content is on that test?
Yes, it is 0.256 plus or minus 0.031 grams per 100 mils.
And that is that above the 0.08 legal limit?
Yes,
And is that above the 0.15 limit?
yes, it is.
And that is at the time of testing, correct?
That is at the time of the blood draw.
Or at the time of blood. So that was my question earlier. So the ethanol amount at the time of blood draw and at the time of testing, you're telling us is the same?
Yes,
Are you familiar with the term antegrade extrapolation?
yes.
Could you describe it to us?
Sure. Antegrade extrapolation is a formula that we use to either calculate the blood alcohol concentration from a given number of drinks or to calculate the blood alcohol concentration from the given number of drinks.
What are some of the factors or individual characteristics that you consider in performing that calculation?
To perform that calculation, would need to know the individual's weight and the blood alcohol concentration. Also, it is assumed that during the number given from the calculation, all of the ethanol is immediately absorbed and distributed, and there's no elimination.
Did you receive any of these on this case?
Yes,
Okay. What information did you receive?
I did receive the individual's weight, and I had the blood alcohol concentration from the lab test.
Can you tell us what, based on your calculations and based on what you received, what would be the blood alcohol content at the time of driving
Oh,
in this case?
that's two separate calculations. Anterograde would give you the number of standard drinks that it would take to achieve that BAC. Retrograde extrapolation would give the blood alcohol concentration at an earlier time.
Okay.
I was able to perform both calculations.
Would you be able to tell us how many drinks would it take to get to that number?
Yes, may I check my notes?
Sure.
Don't read it out loud. You may refer to the notes and then testify, please.
The calculation is based on the minimum number of standard drinks that it would take to achieve the blood alcohol concentration. And in this case, I calculated it to be between 6 and 12 drinks.
Would you be able to also tell us So based on your explanation earlier, would you also be able to tell us now, what would be the, blood alcohol concentration at the time of driving?
Yes, may I add on to my last statement?
Sure.
So the reason that I gave a range of 6 to 12 is because of the volume of distribution. The volume of distribution is the area of the body that the alcohol can distribute to. The general population has a volume distribution between 0.45 and 0.81. So make a calculation based off of both of those numbers. And the number of drinks that I give is a standard number of drinks. And a standard drink is 12 ounces of a 5% beer, 5 ounces of a 12% wine, or 1.5 ounces of a 40% liquor.
And,
I'm sorry, can you repeat your question, please?
so based on all of that, and let me backtrack. What information were you given to conduct this calculation?
For the retrograde,
For both?
for the retrograde, I needed the blood alcohol concentration and the individual's weight. For the retrograde extrapolation, I needed the time of the last drink, the time of the stop, the time of the blood draw, and the blood alcohol concentration.
And did you receive all of that information?
Yes, I did.
And based on all of that, what was your calculation of blood alcohol content at the time of driving?
And for the next, please.
Sure.
Judge, can we have permission to take this with us on board item before we case that amount?
Yeah.
Okay, thank you. You testified that, good morning, first of all. You testified that you received information about the time of the defendant's last drink. Is that accurate?
Yes,
Do you remember that time?
I was given that it was 6 hours prior to the stop.
Okay, and the information that, and do you know what time that is?
The stop, I believe, was at 12:30 a.m. So it would have been around 6:30 p.m. The information that I need from that is just to ensure that there is more than 2 hours between the time of the last drink and the time of the stop. That number is to ensure that the individual has completely absorbed all of the ethanol in their system and they are in the post-absorptive phase.
Okay, and so when you're doing these calculations, you're relying on the information that you're giving being accurate and correct, right?
Yes,
And so receiving inaccurate information could potentially skew the results, right?
yes, I make my calculations based on the information I'm given.
Okay, absolutely.
Okay, you may continue.
Yes. So just to refresh my recollection, actually, no, you didn't give us the number. So what would have been the number at the time of driving?
So for this calculation, we need to ensure that the individual has absorbed all the ethanol and they are eliminated. And the calculations are based off of an elimination rate of 0.01 to 0.025 grams per 100 milliliters of ethanol per hour. So in this case, I calculated the VAC at the time of driving to be between 0.275 and 0.305.
And just to clarify, that is higher than the number that we see here, correct?
Correct.
Now to circle back, you were talking about how the VAC at the time of testing and at the time of blood draw would be the same. Is there any circumstances where that could change?
It's possible for that to change if the blood tube was left open. Ethanol is volatile, so it's going to go into the headspace of the tube. And it could evaporate off if the vial is left uncapped for an extended period of time.
And since you reviewed this case, was there any indication that that happened in this case?
No.
As an expert reviewer, what do you review? I think we talked about that a little bit earlier, but I just wanted to finish up.
Before I release a case, I review the submission form that comes in with the evidence from the submitting agency. I ensure that the officers are correct on our report. I ensure that the suspect's name is correct, that the submission date and time is correct, and that the information on our report is accurate.
And did you perform all of those tasks on this particular case?
Yes.
To your knowledge, were there any deviations or issues in this case?
Not that I'm aware of.
Would you as a toxicologist, if there was an issue with the vial, how would you know?
In this case, I was not the analyst, but the analyst would make a note on their batch worksheet. It's the most likely place to put an issue.
Have you been an analyst before?
Yes.
So you're fairly familiar with that process as well?
Yes.
And again, was there any issues with this case as far as analysis that you could see in your review?
No.
I'll pass the witness. Oh, look, sorry, 1 second, Judge. As an analyst, how do you know that the correct vial was being tested in this batch?
Whenever we generate our batches, we use the IFS number that is associated with the case. And we pull those samples from the refrigerator based off of that batch worksheet. And as an analyst, when I'm testing, I go down my batch list. Each of the blood tubes has an IFS number on it. And each one of my testing files also has the IFS number on it. And I look at both labels and make sure that those numbers match before I do my pipetting.
And do you test the batch twice for quality check?
The batch is not tested twice, but the individual samples are. We run each of our alcohol tests twice. We test the first time to screen for the presence of ethanol. If ethanol is detected, then a repeat test is ordered, and that sample is tested again. And those two results need to be within 5% of one another. And then we report the lower of the two values.
I'll pass the witness.
Hold on. I just want to clarify one thing. You said for retrograde, it was a 0.275. Was that a plus or minus 0.035, or was that in between?
It's a range, and that range, the low number, the 0.275, is based off of an elimination rate of 0.01. The 0.305.
Okay, 0.305. I wrote it down 0.0. I thought he said 0.035, but you said 0.305.
0.305.
God, I must be dyslexic. Okay. Are you ready?
Yes.
Yes. Okay.
Mr. Gasman, you're a toxicologist too.
That is correct.
You do technical review, batch work, as well as final review.
Correct.
And I think you said that you had testified around 37 times.
Yes.
Out of those 37 times, how many times were you testifying for the state?
I have been subpoenaed by the state on all of them.
Okay, so every time you always testify for the state, is that fair to say?
I testified based off of the work that I perform.
How many times have you testified on behalf of the state?
I'm sorry, say it again.
How many times have you testified for the state?
I'm not really sure I understand your question. I am testifying based off of a subpoena, but I don't think I'm necessarily testifying for the state.
Okay, understood. You mentioned that increased alcohol would cause, you would expect to see certain things when a person has a really high level of alcohol, right?
Correct.
Some of those things were trouble with judgment, you said dizziness, confusion, staggering when walking, those types of things.
Yes,
You also said that in your retrograde calculation that you came up with a 0.275 ranging between 0.305.
yes.
What would you expect to see from a person at that level?
It's gonna depend on the individual. It's going to depend on their drinking experience. But they might be slurred speech, they might have trouble with balance, they might have trouble with their vision.
What about their memory?
It depends on the individual. They might have some memory loss of that BAC.
Okay, so we did a retrograde extrapolation in this case.
Yes,
Do you know Ms. Lovey's drinking pattern?
I do not.
Do you know the number and type of drinks that she had?
No,
Do you know how long she was drinking for allegedly?
no,
Do you know whether alcohol was still being absorbed at the time that she was driving?
based off of the information I was given, it should have all been absorbed at that time.
Do you have any personal knowledge?
No,
And then if someone mishears her and gives you the wrong information, would that absolutely affect what results you come up with?
yes, if the information changes, the calculations would change.
And the garbage in, garbage out theory, if the processing, handling, or any part of the process is compromised, would that affect the results?
To what are you referring?
Well, you work in the lab, right? So
Yes.
there are a number of people that handle this sample before it ever gets to you, right?
Yes,
And so if any part of that process is compromised, could it affect the result that you get?
yes, we test the blood vial as we receive it.
Okay. And so if a vial was transported, or let's say it was left in a trooper's car for an extended amount of time in heat, could that affect the biological sample?
It could. Generally, the blood out or the BAC or the amount of alcohol in the sample will decrease over time. Since the ethanol is volatile, it will evaporate over time.
So you don't know whether or not this sample was compromised or handled according to the lab protocols before it came to you, do you?
Before it came to the lab,
Right.
I do not know what happened to it before it came to the lab.
And if something is, and let's say for instance, it was compromised in any way, maybe it wasn't refrigerated or it was left in a car for too long. When it comes to you, you don't know these things, right?
I do not know these things, but most of the research shows
All
that.
I need is what you know or don't know. So you don't know these things, right?
Correct.
And so typically, if you are not aware that the sample has been contaminated or compromised in any way, you would still go ahead with testing, right?
Yes,
And then, in the case that happens, the result could be wrong unknowingly to you, right?
The result would be the result. It
Right.
would not be representative of the blood draw.
Well, I'm asking if the sample was contaminated or compromised in any way, and you don't know about it, you're gonna test it, because you don't know that it's contaminated or compromised, correct?
Yes,
And is it fair to say that if that were the case, and you got a result, there's a chance that that result could not be accurate?
I believe that we're talking past each other. The result is the result, no matter what happens to the sample. When we test it, that number is accurate. However, based off of what you're saying, the number might not be representative of the BAC at the time of the blood draw.
What's the number?
I have a quick question. You said earlier that it's a volatile and that it can evaporate.
Yes.
Is that even if the tube, the gray top tube is closed and sealed, can it still evaporate?
It's possible, but usually no. Like it's stable over time.
Got it. Okay, thanks. Anything further?
Yes, Judge. So based on those questions, if there was any contamination or for example, the blood vial not being refrigerated properly, I just want to double check. You said that the BAC would have been lower, correct?
In studies that I've read, whenever samples are left unrefrigerated, the trend is for the BAC to be lower.
Also wanted to ask you about people's tolerance. Is it possible for somebody who has really high blood alcohol content to seem to other people that they don't have signs of intoxication, such as stumbling over or throwing up or slurred speech?
Sure. So tolerance is basically repeated exposure. And if you do something over and over again, you get to practice it. So if you consume ethanol repeatedly, you will learn how to adjust for the impairment. However, the motor skills that are impaired by ethanol can't really be practiced. So your reaction time is still going to be slower. You still might have issues with your visual acuity. Those are not things that you can practice.
And also earlier you talked about peripheral vision, effect of alcohol on peripheral vision. Is that something that's visible to an officer, for example, or naked eye?
Not that I'm aware of, but I've not been trained for this field sobriety test.
Sustained. Let's.
Could someone with a BAC of below 0.08 show signs of intoxication after having, for example, 1 glass of mixed drink? Again, I'm kind of talking about the tolerance. Could somebody be under the limit and still have sign of intoxication?
Yes, it's possible. There are studies that show that impairment can start at 0.05.
And could they have loss of mental faculties?
It's possible.
Could they have loss of physical faculties?
Yes, it's possible.
So the studies show that a BAC of 0.08 is the legal limit. Why?
In, I guess, original studies, that was the level at which they saw impairment in the ability to operate machinery.
I passed the witness.
Anything further?
I had a question, but it just blew my mind. Mr. Gassman, you talked about tolerance and you said that the more a person drinks, that it could affect like how they might react based on alcohol level, right?
Yes,
Do you know Ms. Lovey's tolerance?
I do not.
Were you provided any information about her tolerance?
No,
So you have no evidence that what you said is in play in this matter?
those are generalized statements done on population studies.
No further questions.
Okay, may this witness be excused.
Yes, Judge.
All right, thank you for your testimony. You may be excused. State, do you have any further witnesses?
No, Your Honor, the status.
Okay, why don't we take a break? I'm going to give you maybe 10 minutes, take a couple housekeeping duties, and then I'm going to bring you up so we can kind of finish up. Okay, please. Okay, please be seated. We're going to stand in recess for about 5 minutes. Let's see who else needs to do something real quick. Come on up, guys. I'll get you out of it. Victoria, you want to come on out? Counsel, come on up.
Morning, Judge. I'm here on Mr. Bella Messler.
Messler, jail or bond?
This will be your judge.
Messler, come up.
She's not from the jail.
Oh, I'm revoking her bond then.
Judge, she's currently in the hospital, as far as I know, but she had a stroke. Officer of this photo and said she was being taken to get some.
Show me.
Examinations done, Judge.
Show me what you got.
Just a photo from which can be held. That's, I spoke with her about coming in and hearing today from the bond violation.
And this don't even have her name on it.
I understand, Judge. She sent me- I spoke to her on the
Yeah.
phone. All she said is she's in the hospital right now.
Sorry.
Okay, do you want to? She had a court for next week, Judge.
No. She's got bond violations. It's DWI second. She's not here. I'm revoking the bond. When you get her here, we'll talk. But until that point, I can't.
I understand, Judge.
Yeah. Okay.
All right.
Do you want to stay on? Do you want to withdraw?
No, stay on, Judge.
Stay on? Okay.
The bond violation is just never getting a, toxic airlock device.
Yeah, that's a big
She's
deal.
not driving, Judge. She doesn't have.
Whoa,
She stays-
bond conditions are bond conditions. You can't just, okay, I'm not going to drive, so I'm just not going to get it.
I
You
understand,
can't.
Judge, but she's been in a shelter. She lives in a shelter in Galveston, doesn't have access to a car. So, I mean.
So you come-
I believe we asked you for a portable originally. You didn't want to do a portable. You said the airlock anyway, is what Mr. Lee told me, Judge.
Get her here and we'll talk. But until that, yeah,
Thank you.
thanks. Mr. Whitehead, come on up.
Mr. Martinez or
Say it again. Who?
Mr. Martinez.
Martinez. Martinez, come up. Oh. You speak English, sir?
Yes, sir.
So you're charged with driving while intoxicated. You're facing up to a year in jail because of the high blow. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
On August 9, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when he observed a Ford F-250 remaining stationary in the middle of the roadway. The engine was still running and the hazards were on. The officer approached the vehicle and banged on the window multiple times, but no one responded. The windows had a dark tint, so the officer couldn't see inside. The officer then called the tow truck. The tow truck driver observed someone in the vehicle right before he was about to tow it. The officer then approached the vehicle and the driver of the defendant exited. While speaking with the defendant, the officer detected an odor of alcohol emanating from his person. The defendant stated he fell asleep behind the wheel. Field sobriety tests were then conducted. The 4 out of 6 clues on the HGM one out of 8 on the walk and turn, and 1 out of 4 on the one-legged stand. DIC was read and the defendant consented to breath test, with the results being a 0.154 and a 0.15.
Did you say there was an accident? Or,
No, Judge. He just observed the vehicle remaining stationary in the middle of the roadway with the hazards on.
okay,
Judge man.
sure.
First of all, I think that's inaccurate. I don't think he said he fell asleep behind the wheel. He said he fell asleep. There's nothing.
So he's asleep at the wheel in the middle of a moving lane of traffic.
No, he's not asleep, Judge. There's nothing to establish that he's operating the vehicle.
He's in the car?
What's that, Judge?
He's in the car?
But we don't know where he's could be in the, it's not illegal to be drunk in the back of your car asleep. It's not an arrestable offense.
Well, I mean, if you're in a moving lane of traffic, right? That's
A
maybe an
citation,
issue.
But not an arrestable offense. There's nothing to indicate operation. The vehicle was running. Nothing indicates he was in the driver's seat. Nothing indicates his foot was on the brake. Nothing indicates the car was in gear. Nothing indicates any admission that he was operating the vehicle by himself or any witnesses or the tow truck driver or the officer, Judge.
So, but he's in the middle of the road.
Yes.
He's alone.
The vehicle's remaining stationary in the middle of the roadway. The hazards are on. The officer walks up to the vehicle, knocks on the door multiple times. No one answers. Tow truck driver, he's about to tow it off, and then he sees the defendant. And then he says, okay, stop, talks to the officer, then the defendant exits the vehicle.
Also, Judge, they have no timeline. They don't know how long the vehicle was there.
I get it, but this is just probable cause, which is a very low standard. It may not be enough for a reason beyond a reasonable doubt, but he's in the middle of the road. He's alone. The car's on. Is it night? Or, I mean, it really doesn't matter. Just, I think that there's enough.
Probable cause, Judge, don't we need to establish he was operating the vehicle?
He's in the car. He's in the middle of the roadway and he's alone. How else? We have no other evidence that someone took off, someone else was driving. He's alone. He's in the car. He's in the middle of the roadway. If he was in a parking lot, that may be a different question. Could be sitting at Lowe's or, you know, that may be a different call. But when you're in the middle of the roadway, you got there somehow, right? Yeah, Mr. Martinez, there is enough probable cause to go forward with your case. Does he have a license to drive?
Yes, Your Honor.
As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication, and I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? When I mean no alcohol, I mean no alcohol from any source. Cakes, candies, foods, gums, energy drinks, it doesn't matter. I just don't care. Just don't use. I'm going to test you for illegal drugs, including marijuana as well. If you test positive after 50 days, it may not go well between us. You understand?
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and or liability insurance. You must maintain liability insurance as well. Otherwise, just don't drive. Because you have a lawyer, I will waive your appearance. You must stay in contact with Mr. Wycheck. He'll tell you if and when you have to come back to court. For now, we'll have you sign a reset. You'll get with Veronica free bond conditions, and then you're free to go. Please, yes.
Just a heads up, we have 2 arrangements.
Okay, come on up. Yeah,
I don't, I'm here, I'm Veronica.
okay,
Okay, can I?
go for it.
So third, 728 camper event, alcohol not detected.
But a tamper event
Right.
means a lot of
Right,
time.
I'm gonna get there.
Okay.
So at 10:46 p.m., replace brake equipment alert issued by Scram Company.
Oh,
They issued the replacement. It says here, this is basically what's on. Defendant has been complying with Fourth of July. My client got the notice. He went the next day and
got notice of what?
Sorry?
Got notice
He
of
got
what?
notice that they wanted to, that something was wrong with the bracelet to take it back. And he went the next day immediately and got the ankle monitor replaced. Furthermore, the alcohol is not detected, and furthermore, this is all they said, you all are saying, the defendant has been complying with portable device. There's no alcohol whatsoever.
When we have a tamper event, typically what that tells me is someone is manipulating the device in a manner to evade detection. They may put a piece of paper, they may put a tissue, they may put something in between the ankle and the device itself. So what I normally will look to is how long was the tamper event? Was it 10 hours? Was it 12 hours? Was it 2 hours? Was it 15 seconds where it kind of just got kind of loose, where they say that that is a tamper? That's, to me, what is important. Yes, it may not test positive for alcohol, but for you putting something in between the device and your ankle. I don't know. Veronica.
Yes, so it looks like,
Peralta, come up.
it was out from 6:23 AM to 8:35 PM. So a 14-hour, window.
However, during that time, to go through portable device, and it was.
Did he blow into a portable device at any time during that time? What time? Could he conceivably have consumed alcohol and we wouldn't have known about it? Because typically the blows are in the morning, in the afternoon, and then at night.
And according to what we got from the pre-trial, no alcohol was detected.
Because there's a 14-hour window where it couldn't detect his skin.
Judge, the fact that they called him up and
Anytime there's a tamper event, they say, come on in so we can figure out what's going on. Anytime there's it doesn't.
And we did have results, so on that same day, he flew into the device at 7:51 AM. On 8:20 PM, it was missed, and then the 10:03 PM, it was an invalid, oh wait, here it is. It was passed, it was
So, but he only blew one time that day?
he flew twice that day, once in the morning at 7:51 and then again.
I'm sorry, I'm revoking his bond. It's a fourth bond violation and it's 14 hours. It didn't have it wasn't touching his skin. It should not do that. So,
he was negative both times.
yeah, yes, you blew at 7 in the morning, then at 8 in the morning, you can have a drink, and then you blow at 8 at night, it's not going to test positive. You're right. But in the in-between, what do you want me to say? It's a fourth bond violation. I mean, I can't just continue to, no, it should not be a 14-hour window. I do this because we've had bond violation after bond violation with you, Mr. Peralta, and it's over today. You will go into jail. I'm revoking your bond. It shouldn't be a 4-hour window. I'm sorry. It's a fourth bond violation. I cannot continue to enable a 14-hour window where you're evading capture. It's not cool.
We use the other bond violation. That's why you never respond, Judge.
Right. And it continues to happen. And we have a 14-hour window. You were going into jail today. Goes with you.
I bring the officers. I promise not swear.
Great. You know how many people swear to me? You know how many people tell me I have a great head of hair? He goes with you. Sorry, it's a 14-hour. I can't just continue to enable it, man. His bond's now at $100. I'll set it at 5,004. Okay. Yeah. All right, coming up. Hey, what's up? Here we go, another one. Celestino, come up.
Mr. Celestino has two devices. He has an interlock and a scram device. The interlock has reaching mechanics with the context security system of the vehicle. And it's currently, his car is completely inoperable. He has to save the money to tow it to the smart start for them to try to fix it. But he's had the scram on the whole time.
What's
The scram device is, the one violation is because his device went into lockout, 7:23, and he never went through there as well.
I mean, he's been being, how do I know that he's not operating the car or doing, I mean, really?
Well, the car is completely inoperable. That's why.
How do I know that? Am I supposed to take someone's word for something? This is, this is a court. In courts, we run on proof, not on the gospel, not on spoken word, not on hopes and dreams and promises. We work on proof.
He did specifically request both the smart start on the trial.
I'm going to give you the benefit of the doubt. And what I'm going to do is I'm going to roll you until Monday. And I want you to bring me proof somehow that your car has been inoperable for the last month. Otherwise, we will have another hearing as to why I shouldn't revoke your bond. But it's unacceptable that you just do whatever the hell you want to do and ask for forgiveness after the fact. We don't operate like that, Mr. Celestino. And you have literally had bond violation after bond violation. I'm giving you the benefit of the doubt.
The first bond violation.
I have had,
I mean, that's what the report has.
this is his second DWI within the same year. He had a DWI dismissed earlier this year. With that other DWI, we had literally bond violation after bond violation. And I think I had to jail him at least twice for a bit different bond violations. And now we're here again on another DWI in the same year with bond violations again. And this time a month without it. The only thing I wanted is to ensure that if you are driving, that you don't have alcohol on board. And now we will see you Monday. I bring me proof. We don't work on the gospel. Do you understand? Okay. All right. We'll see you Monday.
Right this way.
Great.
Sir,
Come on up.
so I'm reapproaching on how Linda's, I sent you and the prosecutors an email showing that he's working at the new job in Waco, Your Honor, all the messages that he has within relation to that.
I don't have a problem that he works in Waco.
Yes, sir.
I just want to know that he's not going to get in a car and drive with
Sure.
alcohol on
So
board.
He sent me a copy of the title, which I just received, Your Honor, so I didn't attach that to the email, but it shows that the owner is Eric Alejandro Fuentes Gonzalez and Monica Latricia Salas Morales. So the car is not his car. He's not gonna have access to the car. The car will be in Houston. And
How do I
he's
know
not
that?
gonna have any vehicle. Like I said, my request is.
How is he getting, so he's going to Waco, right?
He's riding with a coworker up there, right? And so they're sharing a hotel room and a coworker is driving, he's with somebody else. And so that's the only way that they have any place to stay while they're doing the construction. Okay, so we're gonna be riding with somebody else. He'll sign a no driving affidavit, it'll be tested every day. He's gonna report his arrest, which I think gives us,
What's his last name?
Melendez, Your Honor, he's on docket today.
Melendez, come up. So, hey, guys, do me a solid, please. This is Mr. Melendez here. He's going to sign a no driving affidavit. So in a month's time, what I'd like to do is I'm going to put him back on the docket and I want to run a driving record to see if somehow he's been driving. Because if he is, we'll have a contempt hearing. You're going to be signing an affidavit with me today, promising me you're not going to drive. I don't care what the hell goes on in your life. I don't care that a kid has to go to the hospital. I don't care that you have to go to work. I don't care that you need groceries. I don't care that Bambi has to go to the hospital. There's no justification after signing this affidavit that you drive whatsoever. If you do, I can have a contempt hearing and slap you with 180 days every time you drive. And if I want to really be obtuse, I can stack it. Do you understand? It doesn't matter what the excuse is. If you're signing and promising me you're not going to drive, do not drive. The only thing that you need if you want to drive is you must have an interlock. I'm sending notice to DPS in all centers that every police officer knows that if you're caught driving and that vehicle doesn't have an interlock, they're going to take you to jail. Do you understand? Do you see how many people we've put in jail today? I'm not asking much. I just want my public safe, man. All right. So he'll get a portable device. He'll have to blow at least 3 times a day.
Yes, sir.
If you fail to blow in this device, a bond violation report will be submitted and we will have a hearing to determine whether to put you in jail or not. you understand? All
The
right,
only other thing I had to ask Judge on this was because he's gonna be in Waco, if he's called in for a random test, can he get a test somewhere?
he has to be at Quest Diagnostic,
Okay.
nowhere else.
Yes, sir.
Okay.
So just that same
Yeah.
thing within 24 hours, you have to go to the. Quest.
No, not within 24 hours, it's within 4 hours.
Oh, okay.
Yeah.
Okay.
Within 24 hours, it gets out of your system, whatever it may be.
Well, most judges.
That's why.
Would they let you know before, like a day beforehand?
No, they'll let you know the day of. You're gonna have to reach out to pretrial services and say, hey, man, you're up for a test. And then you got to just go. What I would do is find a Quest in Waco, make sure you know where they are and what their protocol is to be able to take a test rapidly. It is your responsibility to take the test, to get that result to him, and he's gonna get it to us. If you fail to do it, I'm gonna haul you right back over here and we're gonna have a hearing. All right?
Thank you.
Okay, good luck.
Thank you.
Hi. Yeah,
I'm reapproaching Mr. Diaz Sanchez, the one that.
everything okay?
That's alcohol on the test.
Oh, he tested positive for alcohol.
The court did order.
Come up,
The court did just order a spraying device, prior to judgment.
come up.
Before.
No. If he tested positive for alcohol now, he probably drank, not like just a couple hours ago.
Judge, if I may.
Sure.
Just the court, this is our first bond violation setting. I just asked the court.
It's a second bond violation.
Judge, it's our first violation setting. I just asked the court to consider, since it did order a screen monitoring device, as well as Mr. Sanchez does have court Wednesday of next week. If the court could order Mr. Sanchez, not just the device, but also to mandate him to AA courses, and we could forward his matters in this court, we can report next week, Judge. I would just respectfully
Hey,
request the
Deputy.
court not revoke
Deputy,
his bond in this matter. Judge.
sorry.
This is Judge, this is our first bond violation.
It's
setting
not
in this
though.
court.
It's not. And had he not tested positive now, then I would have let him go. But he failed to go test. We send him now for a test and he tests positive for alcohol. He failed to go take the test. What was the bond violation that got him here?
That he tested positive for alcohol.
Oh, I'm sorry. He tested positive twice for alcohol. No, you're going to jail, dude. Sorry.
Judge,
It's 2 bond violations. He tested positive twice for alcohol. If I continue to enable, what does that mean?
Judge, I'm not asking you to enable the court did order a screen monitoring device to examine which we're asking to grant him 1 week. And if there's an issue from now until the setting next week, we can revoke his bond then. This is a person who frankly is not had to deal with this sort of bond condition before. I'm just respectfully requesting the court consider the option of putting the screen monitoring device on, mandating him to go to AA courses. Because he has court on Wednesday of next week, we can also mandate him to return to this court and check into the court if there's any issues that we can revoke the bond then. Judge, I would just ask the court consider that as an option, given the
I can't.
situation.
He tested positive for alcohol today. That's just, I tell you what to do. You're here, you've got 3 violent cases. I'm not asking for much. All I'm asking you to do is don't drink alcohol. And you literally, I send you at 8 in the morning to go take a test and you're testing positive for alcohol at 8 in the morning. What the hell does that mean?
Judge, I understand.
Stop. I'm making the decision. You're going to jail. And hopefully now we will get Mr. Sanchez. I hope now we will get your attention. But you cannot continue to violate condition and expect good things to happen. Do you understand? It doesn't work like that in a court. Goes with you. Sorry. I'm setting the bonds both at 5,000 and 2. If he's not able to bond out, then come back and we can talk. But I can't just continue to, it's just too much. You're testing positive for alcohol at this early hour? Really? Sorry. Yeah. All right, come on up.
That's your standard, bond, Judge. Would you consider like 500? My God.
I'll do 3501.
Thanks, Judge.
Hey, come on up. Hey, we need to hurry because I got a jury waiting. I got to bring him in.
Real quick, as
Tell me.
Mr. Hines is here, you asked him to come back to do his PTI from a few days ago.
3504 on here. And then I'll do bail orders here momentarily. Who?
Damon Hines, we were here the other day, he had a mental health PTI assessment he needed to complete, he told him to go by yesterday. Provide.
Oh, did he get it done?
He went right after court, I provided it to Veronica and he stayed. He got it done, we're just waiting on
Great.
mental health to confirm.
Okay,
Correct, Judge, that's all the wait for.
so let's just wait a bit for them to, yeah, okay. All right. What's up?
Just briefly, Mr. Sullivan, it's just, Frank just got a new job. I don't believe he has the funds for the bond as it is. Would the court consider setting the bonds on these matters at 3,500 each?
I'll do 3502 on each, on Sanchez.
Thank you.
Okay, all right. Yeah,
Judge, can we get an arraignment up there?
yeah, come on, bring it.
All right. Page 4, Herrera. Come on up, go over the other way.
You said page 2?
Page 4, there are 2 cases, one was transferred from 46.
So it's not a new case.
No, not even.
All right, coming up, Mr. Herrera.
Yes, sir.
Hey, guys, we're gonna start in 2 minutes. All right, bring the jury back. All right, Mr. Herrera, you're charged with you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
That's right. On August 8, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when they observed a silver Pontiac with a defective stop lamp. The traffic stop was conducted and the officer made contact with the driver, the defendant. While speaking with the defendant, the officer observed him to have bloodshot eyes, slurred speech, and there was a strong odor of alcohol emitting from his breath. The officer also observed in plain view an empty can of Modelo on the passenger side floor. FSTs conducted with 6 out of 6 clues on the HGN, 2 out of 8 on the walk and turn, and 0 out of 4 on the one-legged stand. The DIC was read and the defendant consented to breath test with the result being a .088 and a .090.
Did you say it's 6 out of 6 on the HGN?
Yes, sir.
Okay.
And the officer also located an unholstered handgun in the center console of the vehicle during the inventory or search.
Victoria,
Yes, Judge.
why was it transferred to us?
Because we had the lower cost number. It's just.
Oh, I see.
Filed one day.
Okay, got it. All right. Guys, does Mr. Herrera have a license to drive, please? And are you alleging that he had alcohol in the car?
Yes, Judge, it does say that they located a can of Modelo on the passenger side floorboard. And then in terms of his license,
Yeah, but
I don't believe it's enhanced, Judge.
Eligible judge. He has an eligible driver's license.
Mr. Herrera, I'm going to find that there's probable cause to go forward with your case. It's a condition of your bond. You're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? I don't care what your excuse is, just do not use. If you have a problem with drugs or alcohol, now is the time for you to address it, because if you don't, I will do it for you, and I promise you're not going to like the way that I do it. You understand? You are not allowed to drive unless you have a valid Texas driver license and or liability insurance. If I find that you're driving without either, then likewise to the jail you go. No weapons while you're on bond. You understand?
Yes, sir.
All right. You have the ability to hire a lawyer. How old are you, sir?
26.
What do you do for a living?
I am a choreographer.
You're a choreographer.
Yes, sir.
What kind of money do you make a month?
It can depend, it varies. Depends how hard I work. It could be up to maybe four grand.
Okay, we're going to reset your case to give you time to hire a lawyer. You need to hire a lawyer for this. You're facing up to a year on the gun case as well. Do you understand?
Yes, sir.
Okay, I'm gonna have you sign a reset. We will have you get with Veronica for your bond conditions, and after that, you'll be free to go, sir.
Okay.
Come on.
Thank you.
You got it.
All right, Judge, next is.
Okay, bring it. Let's do it. This is the last one, right?
Yes, Judge, top
Okay.
of 10, order, come on up.
Around, we don't want you near the DAs.
Mr. Hines, go ahead and sign the.
Good morning, Mr. Portis, or Porter, right?
Yes, sir.
Mr. Porter, you're charged with failure leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
The officer spoke with the complaining witness. The complaining witness stated that on December 2024, her daughter had contacted her via public service and stated that someone had hit their 2020 Kia Optima as it sat parked unoccupied at Decaney High School located at 22351 Imperial Valley Drive in Harris County, Texas, and left without leaving any information. The complaining witness's daughter collected the Florida license plate and obtained a video of the vehicle driven by the defendant. The officer obtained security footage of the parking lot and observed the defendant exit the vehicle. Decaney High School staff identified the defendant as a former student known as Thomas Porter. Defendant's mother confirmed that the defendant was driving the vehicle and noticed there was damage on the vehicle. In two separate interviews, the defendant admitted to reversing into the complainant in the Bamwell Road parking lot. The defendant stated he did not observe significant damage to the vehicle, so he left. Complaining witness was able to provide an official estimate from a body shop detailing the cost of repair to his vehicle to be $2,918.82.
Okay. Does he have a license to drive? Porter.
This is Porter.
Does he have a license, please?
The driver license number, but I'm double checking to make sure it's.
You said this was at a high school, right?
Yes, Judge. Decaney High School.
Okay.
Yes, Judge, you just have a driver's license.
Okay. Mr. Porter, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to this high school, not to be in possession of any weapons, and not to drive unless you have a valid Texas driver license and liability insurance. If you drive without either, then I will revoke your bond and put you in jail. There will be no more PR bonds for you. Do you understand, sir?
Yes, sir.
Are you working at this time? Do you have the ability to hire a lawyer?
I get paid from the Texas disability, so.
Okay. Did you want to apply for a court-appointed lawyer?
I think so.
Okay. Deputy, do you mind giving me an application? Are you currently in the military right now? Okay. Mr. Porter, I don't know who you have in this life, but if you endanger my community and I have to put you in jail at a $10,000 to $50,000 bond and you don't have anyone to pony up that kind of money, you're going to be with me for a long time. It takes damn near 9 months just to get a 911 call. Do you understand? I'm not asking much from you. I want my city safe and I'm going to do it at all costs. All right? Okay. We're going to have some bond conditions created for you to sign. Do not leave until you sign. All right? Please.
One more time, Judge.
Last time, because I got to bring a jury in.
Are you gonna require any other bond conditions or anything?
Same bond conditions will continue. Yeah. All right. Come up real quick. The last thing, and then we're going, bringing the jury in.
Judge, I have to walk through, I know Cindy approached the court this morning on Francisco Samano. Can I get your cross number?
Yeah.
It is 263.
Okay.
3789. Thank you, Judge.
Samano, come up.
Right.
Go to that side.
He doesn't see.
Oh, you don't even have a translator though.
No, she's here.
Okay. Tony,
Sorry.
can we borrow you real quick? You are Mr. Samano.
Yes.
So you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, sir. On August 7th, 2026, officers were dispatched to a crash major. On arrival, they met with the defendant to gather his identifying information and statements about the incident. The officer then met with the witness, who stated he was the driver of the 2023 white Honda HRV and was involved in the crash with the defendant's vehicle. The witness further stated he observed the defendant exit the driver's side of his black Cadillac and attempt to run away from him. The witness stated he observed the defendant fall to the ground, so he used both of his hands to hold him down to prevent him from running away while speaking with the 911 dispatcher. The officer then spoke to the defendant, and while speaking with the defendant, he observed him to have bloodshot eyes, poor balance, and a mild odor of alcohol was emitting from his person. The officer then detained and patted down the defendant and put him in the back of the patrol vehicle. Field sobriety tests were then conducted with 6 out of 6 clues on the HGM, 6 out of 8 clues on the walk and turn, and 3 out of 4 clues on the one-legged stand. The GIC was read, and the defendant consented to breath test, with the results being a 0.157 and a 0.154.
Guys, does Mr. Samano have a priority to BI and or a license to drive? Do you guys need the cause number?
Yes, Judge, please.
It is 2633789. Thank you.
He does have a Texas driver's license, Judge.
Okay. Any priority to BIs?
There's no criminal history, Judge.
Okay. Mr. Samano, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
Put me in jail?
I'm telling you not to consume alcohol or illegal drugs. These are your bond conditions. You are not allowed to drive unless you have a valid Texas driver's license and liability insurance in your name. If you violate these bond conditions, then I will put you in jail. When I mean no alcohol, I mean no alcohol from any source. When I mean no illegal drugs, it includes marijuana, vapes, gummies, anything that would cause you to test positive. If I put you in jail, I will not give you any more PR bonds. Do you understand?
Yes.
I will set your bond at $100 and I will give you a PR bond, but this is not a revolving door and you will not get PR bond after PR bond. Do you understand?
Yes.
Okay, we will have all, sign all your conditions and then after that, you'll be free to go.
Thank you, Judge. May I be excused?
Yeah, thanks.
Judge, what was the bond?
$100. Okay, thanks, Tony. Hey, guys, Ms. Kuhn. Katie, you ready?
Judge, was the PR bond correct?
Yeah.
This.
Hey, talk to me.
Well, there's weight on it, so I just have to about.
No, you don't need to. No.
I go very, I'm not. He's not definitely in the stressor and that.
Yeah, well, we're in trial now and they've been waiting a long time. I don't want to keep them waiting. If he's waived, I'll just sign the waiver and we can send him on the way. Really. It's not a big deal. Okay. Yeah, okay. Yeah.
Here I am on Miss Carter's case. You did admonish Miss Carter about her bond earlier. She needs to get a job and I need to reset for 2 weeks.
Yeah.
Just make sure.
Sure.
Thank you. Judge, I know it's a best part of motion.
Yes, I'm waiting for that. I'm not going to bring the jury in. I'm going to wait for that first. Yeah, you don't mind? Who? Oh, okay. Well, let's, I want to do closing first and then we'll let them, they can deliberate whether they, yeah, we're really in the home stretch. Just put it in the office, but tell them to wait. Well, we've been in trial for the last 2 days, last 3 days. Yeah. Ramona, you here?
Yes.
Guys, we're going on the record. Please do not talk. We have to wait for your lawyer, Mr. Riley. Don't go anywhere. Ms. Donaldson, you mind coming up? Ms. Sykes?
I'm not sure where Sean's
They're still up there discussing this.
Yeah, we're waiting for Shanti anyways. Huh?
She might be in the restroom.
I thought I saw her go that way.
Oh,
No?
Yeah.
I'll text me.
Okay. Guys, we're going on the record. Please keep it down. All right, we are back on the record. It is now 11:28, 8/14/2026. State has now closed. There you are. Come on. You made the cut. Now that state has rested, you guys want to discuss anything?
We have a motion to suppress on file and let the court to consider.
Okay.
On the testimony of Deputy Escobar. While we believe that there was reasonable suspicion for the initial stop being the defective license plate or the defective headlamp, we don't believe that there was reasonable suspicion to prolong the detention and DWI investigation based on his testimony. He originally states that the reason he's pulling her out of the vehicle is because he's in fear for her safety and the safety of others on the road because of the alleged swerving, but then he backtracks and says that there was no swerving. There might have been a lane change and at most a minor lane departure. There was no swerving under the transportation. So that is non-existent at that point. He also states that originally in his search warrant and his offense report that there is slurred speech, but on the stand states that there is no slurred speech and that he was confused. So then the only thing that we're left with is him saying that she appeared disoriented. There's no odor of alcohol or anything like that. He's saying that she appears disoriented when he stops her and he concedes that that could have just been her being nervous in a situation that would traditionally have people nervous. So for that reason, we think that that was.
But he did pull her out and he said he did,
But
you
that's
know,
after he pulled her out, because initially,
but officers are allowed to do that.
but he pulled her out to start a DWI investigation and he said that. So I guess my position would be at the point when he decides to pull her out and he says that in the car, he says, I'm pulling you out to make sure you're okay to drive because you are making me fear for your safety and the others on the road. He's initiating a DWI investigation. He hadn't smelled alcohol at that point. He had smelled air freshener and noticed that she was disoriented, and that's not enough to.
Glossy eyes.
And he stated that the glossy eyes could have been for any other reason. It's not conclusive indicators of intoxication.
Mm.
So I think that.
I don't need it. I'm going to deny the motion. I think that there was enough to begin a DWI investigation. Yeah. Not a problem. Okay, are you ready? So, okay, so go on. And so what we'll do now is I'll have them brought back in. You guys, I'll ask you if you have any witnesses. If you don't, just rest. And then we'll get ready for just the jury charge and final argument. Okay, all right.
Did everyone receive their?
23. Yeah, yeah, we got one, don't we?
No, yeah.
Okay.
Well, we don't have one right example. We just pulled it from our other case, but if somebody has something to share with me, so I have it.
Yeah. I mean, I have one for my other case, not for this one, but I thought change names and all that stuff.
Yeah, okay. All right, guys, deputy, do you mind bringing the jury, please? It'll be short. Hey, food's here, so what I'd like to do is do closings and then they can eat while they deliberate. So I'm having them hold the food until we can, so we'll rest, take 10 minutes to get the charge ready, and then we'll do closings. Yeah? Okay. Well, I guess we should have done the charge first. Okay, I guess. Right. Okay, I guess we'll do that and then give them 20 minutes to eat. Okay.
All right, to the jury.
All right, please be seated. Okay, so now state has rested. Defense, do you have any witnesses?
That's rest as well, then.
Okay, great. Both sides have now rested. We have just a couple housekeeping duties to get ready, the jury charge, and then closings. That's going to take probably maybe 20 minutes to get us ready to bring you back out to do closings for you to give you your chance to do what you do. I have lunch ready now, so I just wanted to finish this up, bring you out, get the trial semi-done. I'm going to bring you back out. I'm going to let you go eat, and then we'll bring you back out in 20 minutes to finish it up. Okay? All right, guys. So you may go back to the jury room, eat your filet mignon, your lobster, your whatever it may be, and I'll bring you back in 20 minutes. All right. Okay, you may be seated.
What did it get, Judge?
It's either Treebeard's, Frank's Pizza, or Lenny's Subs. It's always the same thing.
Who decides?
What is it? No, you did not. Did you really?
Who decides that?
That's a first. They do,
Oh,
not us.
y'all think that.
All right. Hey, shall we get started on the charge?
Yes, I'm just trying to get to the 30/22 instructions when I can send it over, and then they informed me that there was some issues with the pronouns, so I want to fix that. So I can just send that. So you fixed it?
Hey, Vic, anything you want to talk about? Yeah, let's do it.
Bottom of one,
Okay.
top of two, multiple bond posted, felt up here.
10,003 on both of them.
Zero.
Yeah,
You gonna do it now or later?
right now.
Condition? Okay.
Like, well, isn't that, I'm not ready for that.
Yeah, for sure.
It's a. Fail to comply, oh, sorry. Okay. All the condition. I don't want to.
On Porter,
Yes. You said no one back to the school.
Yeah.
Weapons and license and insurance.
great. Good job, Stuart.
Weapons, license and insurance.
Yeah, don't go back to the school, no contact with the complaining witness, no weapons, no driving without a license and insurance, please.
Just that school or no schools?
Just that school.
Okay.
I think that'd be,
I only have one.
Top of page 4, homeboy didn't show up.
You did, Judge, but you sent an email saying that it'll be no more bond violations or continued supervision.
Oh, right. He was late 1 minute. Yeah, okay, I remember that. Yeah.
Ready for the next one?
No, let me just, if you don't mind, let me just do these real quick.
So that's why, that's something that I'm going to see. You know, I don't think anything is.
Not bad, right? Did you talk to Peralta, Veronica, already? Yeah, you did?
What was that, Judge?
I was just asking if you already talked to him. So, let's talk. I'm live streaming, so let's talk. Yeah. What, did we do something on Romo?
Yes,
He did?
yes.
Okay, so we'll continue supervision. Okay. Sanchez is the other one. Okay. All right, this, I'm done after Sanchez.
Names called and answer all of them.
Okay, Victoria, you ready?
Bottom of 7, we told council visits to Philadelphia, but I didn't hear the comment.
5,001.
Leo?
Yeah, I already did it.
Okay. Bottom of 8. For Raymond fell the first time.
2501.
Top of 9 is a BBR. Here.
5,000, or no, let's see, this is more. Oh, geez. $10,002.
Leo?
Yeah.
So what did you guys?
Okay,
All right, Judge, next is bottom of 10. Except for Raymond fell here.
2501.
Top of 12 is a BBR that fell to here.
$10,001.
Yeah.
Yeah. Okay.
Next is bottom of 15, top of 16, separate arrangement.
2501 on both.
And that's it. I am missing one attorney that has only on the office.
Yeah, Childs. Yeah. Hey, can I talk to you for a second? Hey, are you guys ready?
Yes, Judge, I'm sending it to Ramona right now. Okay. We've gone through it, Judge, and we're in agreement, so it's just a matter of her putting it in. So we went through it, I edited it,
Yeah, yeah.
and we're all in agreement. Say. They're gonna be at least all the same deputy.
No, it was a different
Or
one.
did I address the one?
Yeah.
Okay.
It was a different one.
So please, they're talking about a charge. Oh, charging. I don't know why I got. Oh, no, it's just for like,
For another case.
for, no, but this one, but jury charge. Yeah. it's just weird.
Because I'll miss the part when they.
Okay, yeah. We're just trying to get the jury charge.
So they're gonna eat, come back.
Yeah.
So there's.
Yeah.
So this, you.
I never.
Okay. I mean, the only other one who has different creator. So I don't know what that looks like.
Yeah, he's. You're done with that one, right? Yeah, so. I think the commission or I think the back. Yeah. He's ready to go. I just need to get his phone. Yeah. It's not his phone, it's that. It's that on video. Even not.
It's actually. And then also that she wasn't as knowledgeable, and so it was just like a double, like what is going on?
Yeah.
You're just like, no, just.
I do my work.
And here's also.
Yeah, that's what I was telling you yesterday, I was like, you just don't like to open it or anything like that, just like block out those kind of questions, because it's like, depending on how you ask it, like, it's just like people to the door to educate part.
Yeah, and I've been almost thought about it for a long time. I was like, dang.
Every time. Yeah, no, I mean, honestly, like, I only get fired up when the defense starts like being shady and stuff like that. I'm like, okay, now that's the, like the other side of you.
Now I got to send you to turn me up.
They're like, you're here to do your job. Like, at the end of the day, it's just what it is. So, I hope you guys are just meeting with like Donald Trump, it's like, based on how you guys.
I reviewed that.
I mean, there's been the same thing, like, you guys are big friends with colleagues after you're done with the trial. Like, this is
Yeah.
fine.
We spoke to cases, so I prefer it to be that.
Yeah,
Right?
exactly. That's for me, it's the honesty, like, if you do something, someone's having this case, I'm not gonna do it, right? But if one day you come to me, like, both ask me one day, like, hey, there's some issues with this trial, I'm gonna believe you more than. Then I would, like, there's always an issue.
First thing you go. Oh.
Este es un familia, un marido, emergency. Sí.
¿Y lo llevo afuera o?
Yes. Este es tu posición.
Guys, would you mind taking 5? Yeah. Hey, would you mind taking a look to see if you guys have any objections to the charge? You know, right here. I know. Damn, I'm gonna ask for so bad I can even tell. It's like I don't have cushion there anyway, so it's like. Yeah, yeah, yeah. Yeah.
Did you keep one? No.
Do you have anything you want to talk about while we're waiting?
No.
No, yeah. You want to talk about it?
No, I don't talk about it, but we have sign.
Oh, okay. Let me see if it's in. Hold on.
Yeah.
All right, bring him up. It's here. Come on. To clerk.
Oh.
Yeah.
Oh, Judge, can I get the docket? I'm gonna start writing on it.
Yeah.
I was thinking.
No.
That's writing.
Yes, we're waiting on his attorney. Mr. Porter, go ahead, sign your form conditions and I'll give you a call.
Yes. Oh, no, sir, I didn't get a copy.
Okay, we'll go for it. Is it ready?
Yes.
Yeah, that's why I didn't finish it. Let me go. Only right this way first. Yes, ma'am. I'm on my way.
Yeah.
Staying over here. I don't see anything wrong with this.
You good? Okay. Are you good?
Yes, Judge.
All right, we're about to go on the record. Just please, Ramona, you ready?
Yes, Judge, I'm ready.
All right, both sides have been given copy of the jury charge. State, do you have any objection to the charge?
No, Your Honor.
Defense?
No, Judge.
Okay, with that, we will bring the jury in and do closings and then let them deliberate. I guess you want to go grab Miss Levy real quick? And then we'll, and Miss Shaw, and then we'll finish up. Hey, off the record. So. Yeah.
Send me something that's. Okay. After that, we did.
Thank you. That's okay. All right, Deputy, do you mind grabbing the jury, please? Thanks.
All eyes for the jury.
All right, please be seated. All right. Members of the jury. Yes, I can see you. All right. Members of the jury, the defendant, Chelsea D. Lovey, stands charged by information with the offense of driving while intoxicated with a blood alcohol concentration greater than 0.15 in Harris County, Texas, on or about October 1st, 2025. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take with you to use during your deliberations. First, I will give you some general principles of law that you must follow in deciding this case. Then I will instruct you on the rules that control your deliberation. Finally, I will tell you about the specific law that applies to this case. The information. The information is not evidence of guilt. It is the name of a document required to bring the case before you. The information cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his or her innocence or produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. It is not required that the state proves defendant beyond all possible doubt, guilt beyond all possible doubt. It is required that the state's proof excludes any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If after you've considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of testimony of the witnesses and materials admitted in evidence. Nothing I have said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meaning provided in these instructions. While you should only consider evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you wish, if you request. You must follow these rules to request that testimony be read back to you. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, 1, states that it has is requesting testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The law requires that you render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant's guilt beyond a reasonable doubt. You may return a verdict only if all 6 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his or her behalf. The defendant may choose not to testify. The defendant's decision not to testify cannot be held against her and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if she had testified or why she did not. The jury must immediately stop any juror from mentioning the defendant's decision not to testify. Rules that control your deliberation. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the lawyers, you will go to the jury room. Your first task is to pick a foreperson. The foreperson will preside over your deliberation and conduct them in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the court, all jurors must follow these rules. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. You must communicate with me, the judge, only in writing, signed by the foreperson and given to me through the officer that is assigned to you. You must not conduct any independent investigations, research, or experiments. You must tell me if anyone attempts to contact you about the case before you reach a verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. After you've arrived at your verdict, you are to use one of the forms attached to these instructions. You're to have your foreperson sign his or her name to the particular form that conforms to your verdict. The law on driving while intoxicated. You are instructed that a person commits the offense of driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. You're further instructed that if you believe beyond a reasonable doubt that Chelsea Lovey's blood showed an alcohol concentration level of 0.15 or more at the time was performed, you will find the defendant guilty of the offense of driving while intoxicated with a 0.15 or greater. And you say so by your verdict. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of driving while intoxicated, blood alcohol concentration of greater than 0.15, and proceed to consider whether the defendant is guilty of the lesser offense of driving while intoxicated. If you have a reasonable doubt about whether the blood alcohol is greater than 0.15 or above, then you will proceed to consider whether the defendant is guilty of the lesser included offense of driving while intoxicated. In this regard, public place means any place to which the public or a substantial group of public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospital, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except the device used exclusively on stationary rails or tracks. Intoxicated means, number one, not having the normal use of mental or physical faculties by reason of the introduction of alcohol or controlled substance, a drug, a dangerous drug, or a combination of two or more of these substances, or any other substance into the body. Or number two, having an alcohol concentration of 0.08 or more. Alcohol concentration means the number of grams of alcohol per 100 liters of blood. Blood means whole blood. You have heard evidence obtained as a result of the search of defendant's body for a sample of her blood. Specifically, you have heard that the search was conducted pursuant to a search warrant. You may consider this evidence only if you resolve a preliminary question in favor of the state. No evidence obtained by an officer or other person in violation of any of the provisions of the Constitution, laws of the state of Texas, or the Constitution or laws of the United States of America shall be used against the accused on the trial of any criminal case. The state must prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. A police officer may conduct a search of the person of a defendant when the officer has probable cause to believe that the search of the person of the defendant will reveal evidence of the defendant's connection to a crime. In order to obtain the evidence from the person of the defendant, the officer must obtain a search warrant. Before you may consider the evidence that was obtained from the search of the defendant's person, you must all agree that the state has proved beyond a reasonable doubt that Deputy Escobar obtained a search warrant stating probable cause to believe that the search of the defendant's person would reveal the defendant's connection to a crime. If you find the facts set forth above beyond a reasonable doubt, then you may consider all of the evidence obtained as a result of the search of the defendant's person. If you do not find the facts set forth above beyond a reasonable doubt, then you will disregard all the evidence as obtained as a result of the search of the defendant's person. Now, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Chelsea Lovey, on or about October 1st, 2025 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, and you further believe from the evidence beyond a reasonable doubt that the analysis of the defendant's blood showed an alcohol concentration of a 0.15 or more at the time the analysis performed, then you will stop your deliberations and find the defendant guilty of driving while intoxicated, blood alcohol greater than a 0.15. If you do not so believe, or if you have a reasonable doubt thereof, then you will acquit the defendant of driving while intoxicated, blood alcohol concentration 0.15, and you will next consider whether the defendant has been proven guilty of driving while intoxicated as instructed below. If you believe from the evidence beyond a reasonable doubt that the defendant, Chelsea Lovey, on or about October 1st, 2025, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, then you will find the defendant not guilty. I will now sign the charge. We will give each side 10 minutes for closing argument, and then after that, it will be your turn. Sake? Do you want a reminder? Like 2 minutes, 3 minutes?
Yes. I'm gonna go just do a couple of minutes. And,
Okay, okay, go for it.
All right, so the elements, what we have to prove to you, that is the most important thing, and I want you guys to really focus on that. What we have to prove beyond a reasonable doubt goes exclusively into the elements. Here, really on the first 5, we're in agreement that on or about October 1st in Harris County, Chelsea Lovey operated a motor vehicle in a public place. We saw her in a public place. We saw her driving. We know the defendant is Chelsea Lovey. And we know it was in Harris County, and we know the date. So let's focus on intoxication. That's our main issue here. And we believe that we have proven to you beyond a reasonable doubt, not only one way through the blood alcohol level above 0.08, but also by showing you that she had lost the normal use of her mental faculties and her physical faculties. So in all three ways, we have proven our case. Again, you don't have to all agree on every single one. Two people can believe, I think they proved it with the BAC. One person says, I think they proved it through the loss of mental faculties. I could see that. One of you could say, no, I saw the physical sign or loss of physical faculties. You don't have to agree on that point. As long as you believe that she was intoxicated under one of those, you're unanimous. We are also pointing out that in our charge, this is an enhanced crime, meaning that she's being charged with having a BAC of above 0.15. And what that means, what that element is, we don't have to prove that she had that BAC at the time of driving. That's the difference. We only have to prove that her BAC at the time of analysis, at the time that they were testing, was above 0.15. Now, if you didn't believe that, then you go to the lesser included offense and look at the 0.08 at the time of driving. But here, we're not alleging that. We're alleging that her BAC was above 0.15 at the time that it was analyzed. And if you believe that, then she's guilty of this crime. I anticipate defense is going to get here and try to poke hole, saying that, well, the analyst was wrong, or there was contamination, or there was an issue with the blood, or possibly there's a problem with the officer, or they didn't see it right. But I want you to just go by what the evidence is showing you. But what proof do you have of what is being said to you? Because we are in the business of making a decision based on evidence and proof, and not just what either one of us is saying to you. So I'll be back here after you hear from defense to untangle what their stance is.
All right, thank you. Are you going to do everything?
Yes.
Okay.
Good afternoon. So we all know why we're here today. Because the state wants you to believe that they can prove that Ms. Lovey was driving while intoxicated. So far, the only thing that you've heard is what her BAC was allegedly at the time of testing. No one has been able to tell you what her BAC was at the time of driving while she was operating a motor vehicle. Now, Mr. Gaswood gave us the number, but I'm gonna get to that here shortly. So first, we'll talk about the reason for the stop. He said that he had reasonable suspicion to stop her because she was committing traffic violations. First, he said, well, she was swerving all over the road. And then as we talked to him more, it went from, she was swerving all over the road to, oh, it was 2 to 3 times to, well, she made a lane change without using her signal. And then she swerved a little bit when I got behind her. Well, Officer Escobar, how long were you behind her? 1 to 2 minutes. Was it 1 minute or was it 2 minutes? Well, I would say it was 1 minute. And then we show the video and it's about 7 seconds before he lights her up. After that, you see her slightly bump the line, and later in the body cam, she tells you, well, I was nervous when you turned your lights on. She wasn't pulled over for speeding, for hitting curbs, or any of that. It was simply she had a defective headlight. How many times are you driving and looking at the front of your vehicle? It was for a license plate light being out. How many times are you driving and looking at your own license plate? You only typically notice when somebody say, hey, your lights out. Oh, thank you. And then you get it checked out. So Officer Escobar, he said that multiple times on the stand, she was lying about drinking. Well, she's not on trial for being dishonest. He also said, well, I asked her a scale question. I said on a scale of 0 to 10, how drunk do you feel? And she gave a 3 to 4. Well, let me remind you, having a drink and then driving is not illegal. Having a drink and then driving or feeling the effects of alcohol is also not illegal. It's illegal to drive while intoxicated. So then we asked him, well, the scale question is not a part of what you usually would ask somebody. Why did you ask that? Did you ask her to use it against her? Oh, no, I didn't ask her to use it against her. I was just asking her just to ask her for my own knowledge. But then he goes and he put it in his report. And then he also puts it in the search warrant that he presented to a judge to get a warrant to take her blood. Is that not using it against her? Then he said on the stand, he testified for a good 3.5 hours. And throughout all of his testimony, he never talked about slurred speech. He only talked about her driving, and then he says when she was a little disoriented, never slurred speech. But in his search warrant, he put that she had slurred speech. So then Attorney Sykes said, well, officer, you never mentioned slurred speech, but it's in your report. Oh, that must have been a mistake. So are we submitting mistakes and having judges look at those and give warrants to take people's blood by force? Is that acceptable? Aside from it not being acceptable, he swore to that affidavit. He said he raised his right hand and swore that everything in there was the truth, but then he got up here and basically told you he lied in his affidavit. He gets to review his affidavit before he submits it. There's no reason there should be a lie in the affidavit that he's going to give to a judge to use to make a determination. He also testified that he felt like she was intoxicated because she was circular, or she kept asking the same questions over and over. Well, he asked her the same question multiple times. Where are you coming from? Where are you going? I think it was well established that she said, I was going to get snacks for me and my sister. That's where she was going. Now, he asked her the same questions multiple times because he thought that he was going to slip her up and she might say something different than what she had said before. But her story was the same. I was going to get snacks for my sister. Then he tells you that she was showing signs of deception. He said that she was pulling on her clothes and she was rubbing her hands on her pants. And in his training and experience, it is signs of deception. Now, he was trained by another police officer that was trained by another police officer that was trained by another police officer. Like, do you get my drift here? Police officers say it's a sign of deception. But the funny part about that is while she was rubbing on her pants and he wants you to believe that she was being deceptive, that's when she told him, officer, I did have a drink. And then guess what he did with that? Deception. He put it in his report and he put it in his search warrant. So he only wants you to think she's been deceptive when it's not supportive of his position. But if it's something that he feels like he can use against her, he wants you to take it as truth. So if she was rubbing her pants and being deceptive and said that I had something to drink, I guess you gotta believe that she didn't have anything to drink, according to Officer Escobar. Then we'll talk about Selena. This was the lady who did the blood draw. I mean, I don't have much about Selena. She testified that she could not tell you what Chelsea's BAC was at the time of driving. But the one thing that I do want to point out is that collecting blood is a process that requires attention to detail. You're sticking people with needles, you have to find a vein, you have to itemize tubes, you have to put names on it, you have to look at details, names, birthday. It requires a lot of attention to detail. Now, Selena was the one who took Chelsea's blood on the day of the offense. Then she came on the stand and she sat here with Judge, with y'all, with us, and we all watched the blood draw. And then Attorney Sykes said, well, was Miss Lovey in an orange jumpsuit? And she was like, oh, I don't know. What you mean you don't know? We just watched it. So we can't trust that she can sit in court on the stand and testify against somebody or for somebody and look at a video and remember what she saw. How can we trust that the process that she went through followed the protocol when she can't remember something that just happened 30 seconds ago? Now we'll move on to Palmquist. This was the toxicologist one that testified. You heard her say, I just tested blood. I don't know what happened before it gets to me, which means if it's contaminated, if it's labeled wrong, I don't know none of that. I just put it in the machine, let the machine do its thing, and then I give you a document, and then I just come in and testify and I tell you, I don't know what her BAC was at the time of driving. I just run the blood, that's it. And now we have Gaskin. This was the toxicologist too. This was the last person that we heard from. Now, he got up there and he testified, he was the only one that could give you a proposed number at the time of driving. But let's unpack it. The first thing he said was, with a BAC that high, as high as they're saying her BAC was, there would be some physical impairment, right? She would be staggering, she would be falling down. Well, you saw the video. She stood without issue. There was no staggering, there was no falling down, there was no leaning against her car, the officer's car. She stood there without issue. That means there is no physical impairment. Then we get to mental. The officer asked her what was her driver's license number. She gives her driver's license number from memory. The officer did not get like the last 3 or 4 numbers. She starts in the middle of her license number and gives him the additional numbers. He also asked her again multiple times where she was coming from, and she answered without an issue. Then he asked her to perform the test. He was like, well, can you do the HDN test? And she did it. Then she was like, well, what if I don't? And then he also said she was trying to say things to escape the situation. I ain't never heard nobody tell you something that's gonna make you take me to jail. Who wanna go to jail? What she was doing was thinking logically. I want to cooperate with this officer, but as she's cooperating, she's like, I don't know if this is a good idea. What happens if I don't? The fact that she asked what happens if I don't 3 times is not going circular. It's not her not choosing to participate. It's her trying to understand. She kept saying, what are my options? Now, he was giving her an answer, but it wasn't a clear cut, like, you can do this, and if I decide that you're not drunk, you go home. Or you cannot do it, and I'll take you to jail. But what really would have happened if she would have did it, if she would have went to jail anyway, or she could have not done it and still went to jail. It was a loose move. She was gonna take the ride. So all of that going back and forth, he said people typically try to escape situations where they have things to lose. People are not trying to plead and bargain, or they're not even thinking about what they have to lose when they're mentally impaired. So you don't have mental impairment. The officer understood everything that she said. All of her responses to him were appropriate for the situation. She was thinking logically, what happens if I do this? What happens if I don't? Okay, I'm gonna cooperate. Okay, again, really, if I don't do this, like, am I in trouble? This is her mentally processing this situation in real time. So then we have the number. The state introduced evidence that it was a 0.25 at the time of testing, And then Gaston said that, well, based on my calculations, I did a retrograde extrapolation of by the time, or at the time of driving, it might have been a 0.275 up to a 3.0. 0.275 up, that's a big range. Well, how many drinks would that take? 6 to 12? That's a huge, 6 drinks versus 12 drinks? If you don't know, that is reasonable doubt, and that's not guilty. So this 0.08 number, this is not here, because he also said, well, my calculation is based on the information that's given to me. Now, the only person that's giving him information is Escobar. And Escobar already proves to you that he's not truthful. I don't care if you think that it's a little white lie, because my response will be to that is, how many lines are okay in a search warrant that a judge has to use to issue a warrant to get someone's blood? But he says, well, the only thing that I need to do retrograde extrapolation is the time of the last drink and her weight. Well, Officer Escobar never asked her weight in those questions, and we saw that on body cam. So where would he have gotten her weight from? Now I can give you where he may have gotten it from, right? He might have gotten it from her driver's license when he ran her on the MDT system. But when was the last time anybody in here ever went into DCS to get their license? I'm about 30 pounds lighter on my picture. Which means that if he was to use that calculation to get my BAC, it would be incorrect. Now you have this instruction that the judge is going to send back to you. You'll have a copy, which means you can read it. And there's this part that I want to point out to you. It says, before you may consider the evidence that was obtained from the search of the defendant's person, it's talking about her blood, you must all agree that the state has proved beyond a reasonable doubt that Deputy Escobar obtained a search warrant stating probable cause to believe that the search of the defendant's person will reveal the defendant's connection to a crime. And then down here at the bottom, it says, if you do not find the facts set forth above beyond a reasonable doubt, then you will, not you may, or you might, or you can if you want to, let's say you will disregard all evidence obtained as a result of her person, which means you don't get to consider the blood. Let me remind you, having a drink and driving is not against the law. You saw how emotional she got when they did the blood draw. Now, while it might not be reasonable to some of us, she also started crying in the middle of the trial when she saw that part again, because it was just that traumatic to her. People have fears of certain things. For her, it's needles, right? And so, again, if you believe that that search warrant should have never gone to that judge to be signed with a lie in it, and let me give him the benefit of the doubt. Maybe he didn't mean to lie, but it was a mistake, according to him. But again, if you believe that a judge should never consider a search warrant with a lie, a mistake, a miswording, or any of that, you cannot consider the evidence. You cannot consider the blood because it was illegally obtained. You are not gonna, we are all citizens of Harris County. At any point in time, any one of us can be stopped by an Officer Escobar or somebody like him. And I'm gonna ask you this. Would you be okay with an officer lying in a search warrant?
Objection, Your Honor, violation of the golden rule.
Just be careful, please.
Okay. Officer Escobar lied, we all saw it.
2 minutes.
Because
2 minutes.
Because he lied, and he got a search warrant based off of a lie, we're not gonna say that that is acceptable, and we're going to find Ms. Lovely not guilty. It's the law. You might not like it, but it's the law. Lying is not okay. Sitting on the stand and providing testimony for 3 hours and then changing it up when somebody asks you something, that is not acceptable. He only changed it and admitted to it because we asked him about it. If we had never asked him about it, that line would go all the way to a guilty verdict. I'm not gonna let that happen for my client, and I'm asking you to not let that happen. And I'm asking you to find Ms. Lovely not guilty.
Thank you. Are you ready? Okay.
Talk about grasping at straws here. It is, there was no lie. Officer Escobar did not change what he said the whole time. He sat there and he told you that he heard slow speech. And then when counsel asked him, but you wrote slurred speech, and he said that was a mistake on my part. Slurred speech, slowed speech. It is a problem with the speech that goes hand in hand with being impaired. So that's that. He did not lie. That's not a lie. He saw glassy eyes. Counsel didn't talk about that. That is in his affidavit. He's putting the signs and the correct signs that he observed. He had probable cause to stop her. He saw the broken lamp. He saw the lamp that was out on his license, on her license plate. And on top of that, he saw swerving. You can even see it. It may not be as clear as we would like to see it, but if you watch, and let me point out, we couldn't watch all the videos here for the purpose of time and trial, but you'll get, when you get back there, you'll get every single one of these videos and you'll get to watch all of it from beginning to end and decide for yourself. If there's anything missing or if there's anything that you want to rewatch, you are more than welcome to, and I actually encourage it. You can see her car coming, and not even with a slow speed. She's going pretty fast, and she's all the way on the other lane as she's coming. It's hard to see the swerving when she's coming from the front because of the angle of the officer's car. But as he is turning and gets back behind her, she's all the way to this lane. No signal, you can't see a signal. That is the swerving that he was seeing with his eyes. Counsel talked about how long he was behind her. They didn't ask him, how long were you behind her when you light up your car? They said, how long were you behind her? And that's what he said, probably 1 minute, because he's following her until she stops. And it is about 1 minute. Does that matter? Does that go to any of the elements that we have to prove? No. That search warrant was obtained legally, signed by the judge, reviewed, and legally executed. Not remembering a jumpsuit when you're a blood tech, when you are put there to focus on your job and what you're doing. Grasping at straws here. Again, they want you to believe that the science is wrong, that the officer is wrong, that everybody's made a mistake except for the person who actually made the mistake. Her blood level alcohol is over 3 times than the legal limit. I want you to let that sink in. Whatever mistake, if there was any, wouldn't have made her blood alcohol level to that point. And if there was a contamination, the scientists told us that her blood level alcohol would have been lower. There's no proof, there's no signs that there was any contamination, that there was any loose tops. Everything was sealed. You saw it in the picture. They take a picture at every level of their testing. There was nothing wrong with their process. The scientists are not here to testify for the state. They are here. This is their job to test samples, and they are here to testify for what they observe. They are not prosecutors. They're scientists. They cannot care less who is on what side. They just care about the science that they're performing.
2 minutes.
Staggering, falling. If somebody had a blood alcohol level this high, they should have been falling, they should have been staggering, they should have not remembered anything. You all know that's not the truth. We all know that person that can drink a whole bottle and still be fine, dancing around, you know, talking, remembering things. Does that mean that they're not impaired? That just means they have a high tolerance. It doesn't mean that they're not impaired. It doesn't mean that once they get behind that car, that they can see their peripheral vision good, that they can react fast. Impairment we have proven to you in all 3 ways. The only person that made a mistake was Chelsea Lovey that night. She might have thought that that was the worst night of her life, but if anything, Officer Escobar saved her life and probably somebody else's life. Who's to say if he hadn't had that keen eye to see there's something not right and pulled her out of that car, she could have killed someone. 3 times the limit. I want you to remember that. And again, I want to point out that we do not have to prove that her blood alcohol level at the time of driving was 0.05 or 0.15. We have to show you that it was at the time that it was tested, because it's so high. So at the time that it was tested, if it was about 0.015, then she's guilty of driving while intoxicated with an enhancement. And if for some reason you think maybe it was less or maybe it was lower, she's still above 0.08. No way, no how. Nothing but that.
Okay.
So there is one verdict, and there's only one verdict that is supported by evidence here, and not just assumptions. And that is the verdict of guilty. Thank you so much.
Thank you. All right, ladies and gentlemen, it's your turn. Time for you to deliberate. If you'd stand, we're going to escort you out back into the jury room.
All eyes for the jury.
Hold on, deputy. Well. All right, thank you. We'll be in recess once they're excused. All right, we're in recess. Be seated. We're off. You made sure that the alternate. I got number 12 as the alternate, right? Yeah. Okay.
Judge, we still have a couple.
I don't, where is Miss Chan?
I have a question about tomorrow. I am, I'm just waiting, they were waiting for, mental health to verify that he's going over there. So I'm waiting to get.
And she emailed it yesterday to see. Instead of the Monday, right?
No, if they don't have an answer about, yeah.
I think last minute. Small. Monday, to see if, stuff is complete. Yeah, you're welcome. Look at this, oh, we all messed up. Right?
Yeah, that's not good if you get on Friday.
I mean,
It wasn't our fault, we just didn't have. It was 9 on juries on Tuesday. We would have been done on Thursday, we would have had juries on Tuesday. And we did not. So Mr.
It's a Friday, we're all having our phone. Okay.
I actually did do it on Fridays because I think there's children also.
Yeah, they have some.
they don't,
Discoveries
as much on.
It's
one
one
of
of
the
the
things
things
that's
I didn't see any of
Never know.
Yeah. The juror, I think I was. Yeah, that's what I would say.
Hey, did you ever hear from your attorney?
No.
That I did for you.
Yeah, no problem.
Yes. I think. I know.
Yeah, everything's trying to be, I'm gonna print out.
I think it was because it was his first time ever testifying.
But that's okay.
Yeah, but
You
so
know,
I was
you
like,
know your part, so you know
Yeah.
what you're supposed to do, it
Yeah.
doesn't matter, you have to be him, so he can give you
Yeah.
information.
Yeah.
It doesn't matter how you get it first.
Yeah.
You did okay.
Yeah, you did great.
He was very awful.
Yeah.
Hey. And then, with
Yeah, he's it was so much. I know, I should have just been more prepared for, I think I wasn't as prepared for his, his was the longest. And I was like nervous about missing, the parts, because pretty much all the evidence had come through him. So I'm like, I was like thinking 5 things, am I at the right point? Did I miss, and I did miss one of the evidence. So that's what I was worried about, but I need to stop worrying about that. Yeah. I was Yeah. Just, yeah, everybody always, I've had him in a few cases, but I never got to. Yeah. Yeah. I think I was really good because that's love, yeah.
I was like,
I know I'm
but she's good at asking the questions and picking up those questions, like the follow-up questions, a lot of maybe prosecutors don't know how to do. They just go based on the script and they stick to the script and they're like, hey, we said that, they did that, like, move on, you know?
You just.
The video casting says that somebody in Blanche is supposed to. Because when she.
Exactly.
It just said. And she said, oh, yeah, people was taken out of place. So I generated it from, then she sent me an email saying.
I know,
She
it's
said,
just something what you like.
somebody in Blanche is supposed
We'll
to
be
show.
going over the next 3 questions. I'm like, oh, shit.
Blanche.
It is what you're like, it's not figure out, because I'm not gonna want to decide. For my questions, even when I do DNA analysis, all of them, I have headings, so like I know where I'm at, like I'm talking about, like I was doing with them, background education, background training, and I
Can leave it like that.
Literally like a step by step on what to do.
Yes.
Because
They both work for the people.
Analysis, the process of that.
That was my thinking, but I didn't want to publish it, when we could change it and then just.
Yeah.
No, and as you do.
Yeah. I mean, I really do,
They have the last one. Do you know what you're gonna give?
if they ask for it. Okay, got it, I got you. No worries.
Yeah.
Okay.
So when you go.
So.
So if they.
I'm gonna
So
come.
you have to have the charge.
Okay.
And then they'll send that.
The question?
We'll go.
Yeah.
I mean, but.
2 times more burden than it.
I would-
Two, 3, 1, 6, 1, 5, 2, 1, 1, 2, 1, 5, 2, 1, 5, 2. Brandon mentioned.
Yeah, you can put some of that. Put-
Is it 2, 2, 1, 5, 5? But she's not 2, 1.
It's obvious.
No, I said awesome.
No, yeah. It's fine.
You missed her also.
Yeah, thanks a lot.
One by top.
It wasn't good.
I just got you.
We'll draw it all.
It's
not there.
And then someone could put in on.
Right, if you can. I think I need to have a question, okay?
Okay.
But
Get the phone from Malcolm.
Evidence, yes.
Okay.
So you can testify. And then you gotta go over the law. But sometimes I really told them during one day. So I kind of like skimmed through it. But I need to find, she's gonna show me her process, because I don't have I feel like I don't have the right process for opening. That's another thing with immigration, you don't. Yeah. You know, they can't get only the decisions when it's.
I have a different.
I mean, just.
Oh, you can,
Okay. I was like, who is it? It's okay before I say, 3780. Thank you.
So the first.
Tackle files with an E at the end.
Give me a wait, 30.
Street. Number 106.
And I got here. I had no idea.
And so, 77016.
So I saw her and I'm trying to.
Yeah, that's one of those.
But good thing is that a lot of times I talk ahead of my slides. I think I just have them.
You have to try to. Will the officer be able to let him know and like have him sign?
Yeah, so then you can sit.
Just do that. Those are felony, right? Those are felony, John, the felony too.
Next one. He's been not giving us.
Okay, just got it. I'm telling you, small call. 22155, but if you don't look for it.
That has to be more interactive.
Yes. It doesn't change. 22155. 100%.
Oh, I don't think that.
I also feel like a business one.
Yeah.
Yeah.
That's what it's 22155.
Oh, that's actually some people just won't shut up.
Yeah.
And if I show them the whole that.
It's like a clerical error of the A1.
Yeah.
And it's like. I need to be a.
Yeah. Probably.
No, you didn't have to.
Yeah, I know, but like, I know the. And it's the back. I was not the more and then.
Yeah.
I'm a good for you, so.
So for me, ultimately, we try to keep it short and sweet as much as possible. We don't want to talk about the evidence that is going to be presented because the list of things that is going to be presented, right? What children that like what we talk about is, evidence jury, throughout this trial, you're gonna, working for the law intoxicated, and what's, it has to prove to you, one, you about the elements that we discussed during the jury selection. What you're doing here is evidence that you're going to be that we conduct a traffic stop. We conducted the legal investigation. The other thing what we observed, why he was able to come in as intoxicated, and what led him to the rest of the public was intoxicated. I don't really talk about the number because I don't know what to think about the coming in now. Well, after he conducted his investigation, we will, testify that he believes mental faculties that he was a physical faculties. And based on his observations, that is what the request is rectified. Whether it was denied or not, whether or not she did blow, whether or not the blood was taken from. And then the jury, you also hear evidence from the analyst and learn how it's just. After you hear the evidence, you see that everyone has. We go to see that we can see that we go to throughout this trial, but we have to see the observe the body of the camera, we get the agency, something like consultation of the observer.
Let's go there on the framework.
Correct. Correct. Because sometimes you have something that in down doesn't have it out. Right, for the kid cases, right? The kid cases, you have some other story, like, what you're learning is that this person is I was stressed, this person was, you never try to persons. You can actually get to see it from, like, so very interesting. I'm not going to take this whole time. I'm gonna let her tell you what we did. And how we built the trust and how we set ourselves the rest and how we did that something. Those things, I don't get the detail because again, we have no. And I'll let her, I know what I've seen is I'm looking for this. You know, the trouble.
Like half of the cases are in the. And then in the opening, when we talk about it, and then it is. Yeah.
You understand. Nobody will understand. Like for kid cases, I don't have to say, hey, I'm talking about them.
Yeah.
Because you know what I'm saying, right? But then they're telling like, oh, and
So you just talk about meeting the start and the officer.
You bring it, so it's like potential arguments, you know, that you're getting custody. And that's the game.
It depends, right? So like sometimes you don't always know where they're going, especially when it's so clean cut. The way that I attack it is I'm telling the jury, I think it's up to you to decide if there's it's up to you to, I want you to listen, I want you to focus. Like what we say is not evidence, it's not what we say is not evidence.
we want you to go the testimonials and observe the evidence for stuff.
You mean in opening saying what the defense is?
Yeah, basically, the defense is gonna say.
I wouldn't,
Yeah.
I wouldn't do that till close, because, if you don't wanna say something that's gonna be no offense, you think you understand. You have to- Well, that's not what I want. So you don't wanna say something, and then they come up and say, actually, that's not it, but I'm just gonna say this and that, and then all of a sudden. You don't know what to do. Yeah, yeah. Oh, well.
I mean, that's really so, because that's another reason why, I always tell her, like, we never give us a chance to talk to the jury. We always talk to the jury from open doors and closed doors, right? But realistically, meet for open doors. Remember the jury, the judges went over this jury charge, and I know that it was a lot, and it's not for a long time, right? But I just want to focus on some basic things, so just portion of my closing statements. I want you to really focus on, and page whatever your speakers, whatever it is. He's providing the evidence, so the lawful routine. What this basically says is that if you believe that the officer did not have probable cause to obtain a search warrant, then you would disregard the search warrant, and therefore disregard it. However, you would have done this based on the documentation, based on what they claim actually did. That's the question, right? One question. They probably want the other. And in this one, it's basically you that we can always try to refer to about 1.5. But if you find that the case is wrong, then therefore you can then consider it a lower option goes to 1.5. We kind of explained that we do that, we don't need to be explained. Be like, after, the time comes up, I want you to pay close attention to what the parents statement was good here. I want you to say like, are we providing you excuses for each and every one of them, don't we have explained everything? And all the time in the Constitution, are just trying to make excuses for each one of the schools that done, right? After they're done, I get to come back up here and I'll talk to you about what the evidence out there.
It's a question. Can you bring the judge?
And that's how I walked there without the church, I'm like, what? I guess that's not gonna talk about that.
I thought, I thought.
Yeah. And I guess it might be
Oh, yeah.
in the edition.
They're asking the question. Yes.
For everyone,
Oh, everyone has to be there.
Oh, my God.
Everyone has to be there.
Hey, guys, I have a question.
Yes, guys, we're looking for defense right now.
Oh, Stacy's here. Victoria.
No, we're looking for the defense.
Yeah, but Stacy's here. We've been looking for her too. Hi, Stacy.
Hi, yes, I'm a person on Javon Wiley and Travion Bush.
That's okay. Give me 1 second. We got a jury out and we just got a question. Let me address this real quick.
Sure.
Well, yeah, but I still need them though.
the defendant is texting.
Okay.
No one's going to.
I only have an email.
Yeah.
Hey, Ramona, if you want to tell her to zoom in, I think that would be sufficient too if they're out. Or maybe they're on the base first floor.
I was just gonna.
Oh.
I was out there. I just know the defendant, she's. Did you call? Okay, you come on.
They're coming up? Yeah, come on up.
Little question, Jeff?
Yeah. Stacy's here, by the way. But I'm gonna wait for. Thank you. So just put yes, and here it is. This- Oh, no, you could just, yeah. No, I would say just, yeah.
I'm gonna ask the defense if they're not. If they're just requesting evidence, I would just ask that we just send everything back, so you get questions and everything.
I can't do that, I don't think.
Oh.
I gotta wait.
There's some judges that send everything back, and then there's some that just, when I got this phone, we're just gonna send everything back, and then some.
Hey, there's a question, they want the body cam video.
Are you supposed to send in all the evidence stuff, or we just want to send it?
Yeah, I don't want.
Yeah, let's just send just the first body cam, because I think that's what they really want. We gave them a computer as well, so. Okay, Ms. Child,
Good afternoon, Judge. I had Javon Wiley and Travion Williams that both had BVRs. I don't know if you've spoken with them. I have.
come up, Mr. Riley. You were on bond for a very, very serious felony. While on bond for that felony, you pick up a violation of a protective order. The only thing I ordered you not to do was go out in the middle of the night. And here we are. I have a bond violation with you where you were literally out over and over and over and over. 3:57 a.m., 2:16 a.m., 4:20 a.m., 1:08 a.m., 3:58 a.m., 11:33 p.m., 11:15 p.m., 11:33 a.m., 4:16 a.m. Ms. Childs, tell me about your client.
Yeah, he was telling me something about his sick child. I think his sick child has been in the emergency room for the past couple of weeks, and I think he can add more color to that. Not excusing him violating his bond.
Do you
but I
have any
know he's
proof of
been
that?
out of that.
I'm trying to tell you, so I've been getting calls from preachers saying that, like, they've been calling me when I'm literally in the house saying, where are you at? And I'm saying I'm in the house. I asked them, can they show me where have I been going? They told me they couldn't tell me, they couldn't tell me. I tried to get more information about where am I going, about where.
So you go to the hospital at 2 a.m. and then you're back at 3:26 a.m.? Is that what you're trying to tell me?
I only went to the hospital one time.
No,
I
I
have
think,
here,
I think Judge, he's telling you that it's showing that he's not at the location and he is in the location. He's asked pretrial services to show an exact ping of where he is and they're unable to do it. So it's reading that he's out when he's in.
That's what I'm
So these conditions came from the magistrate and he has a curfew device. He does not have a GPS device, which is why we can't pinpoint the location. We just see that the device is leaving the house and entering the house.
I don't know what to tell you. Do you have proof that you went to the hospital?
I mean, I can call my mom.
No. Where did you think you were coming today? To the beach? You were literally out over and over and over and over. You were given a curfew and you were violating that curfew over and over. If you know that you have a child that has to go to the hospital, you contact your lawyer and you say, hey, look, this is a situation. Can you reach out to the court and let them know that I've got these issues?
I did. I contacted my lawyer, told him my baby was in the hospital. I never went to the hospital.
When? Oh, so you didn't even go to the hospital?
No, I did, but the next day I came back. Preacher called me again, asking, you were out last night, you were out last night. I never went. Like, I don't go nowhere. When 7 o'clock hit, I'm in the house. I don't go nowhere. I don't leave nowhere.
How do we have proof that he's out?
Because the device showing that he's leaving the house and then it'll show whenever he re-enters the house. So the device has a pinpoint location of where the house is. So when he leaves the house and it passes that line, that's when we can deal with it.
Yeah, can I ask something about that, Judge? Is the line like at the mailbox or is it at the front door? Because he has been contacting me constantly, like I'm in the house. Like ever since I've been appointed, he's contacted me almost daily.
I understand that, but the fact remains is that he's out in the middle of the night. And I don't want you out in the middle of the night. It's not going to go off for for giggles, man.
I'm just trying to see, like, can y'all please show me where have I left the house?
It's not gonna happen because the monitor's not there to track your location. It only tells me when you're going in and out. All I know is that it's over and it's over and it's over. It is 7:22, 7:30, 7:31, out at 4 a.m.
I don't know.
8:1, 8:2,
Is it me walking?
8:3, 8:4, literally every single day. You have 1, 2, 3, 4, 5, 6, 7 bond violations. At a minimum, you're literally going out every single day in the middle of the night. Mr. Riley.
I'm trying to, like.
Mr. Riley, Mr. Riley.
That's why I've been contacting my.
It's over. It's over. It's just way too much.
That's why I brought the box up. She told me to bring the box with me. You feel me? I don't know if it's me going in my garage. My granny's a WFC. I'm in and out.
At home means at home. It doesn't mean the garage. It doesn't mean the mailbox. It doesn't mean this. Home means home. And there's nothing that you can justify to leave, not even going to the hospital, Mr. Riley. No, you're going to jail today. That's what's going to happen. It's just way too much, over and over and over.
I asked, then preacher told me they was going to try to send her like the map from where I'm going. I still haven't got the map, so I don't go nowhere, sir.
Pretty sure I did not say that.
No, see, that's what I got the messages between my lawyers. She said that if I needed to my lawyer so she could contact preacher and they can send her the map. I just called them yesterday before I told them all of this. They told me when I go to court, I needed to bring the box with everything. Every time they called me and told me why you out, I told them I'm literally sitting in the house. I'm sitting in the house. Every time they call me, I contact my lawyer. Don't go nowhere. I don't do nothing. All I do is help my grandma and do stuff with my baby and go to help my mom at the daycare. I don't go nowhere. I don't leave out the house. I don't do none of that stuff.
The evidence points differently.
Can you show me where have I been going?
I've already answered that question for you and I'm done. You're on bond for a felony assault. You've picked up a violation of a protective order and now you continue to violate bond conditions at least 7 or 8 different times. So I would find by clear and convincing evidence that you refuse to comply with bond conditions. You were out on around $50,000 in bonds and you knew, or you should have known, when you were given the conditions, this is what you can and can't do. Stop! If you have any questions, you reach out to your lawyer. If that doesn't work, then you come to court. You just don't do what you want to do and ask for forgiveness after the fact. Courts don't work like that. It goes with you. This is not up for discussion. Who is your second guy, Ms. Childs? Who is the second one?
Williams, Judge,
Fabian Williams, Judge.
page 18, he came back negative.
Come up.
So,
This is Mr. Williams.
yeah. So
Okay.
recent history on 7/27, he was positive for THC. On 8/3, he was a no-show, and that was the BDR. And so today he tested negative.
Good job.
And can I say something about this judge first? So on 7/27, he talked with pretrial and he let them know that he was going to test positive before he even tested because of, I guess, whatever marijuana he had ingested prior to this.
I'm continuing his supervision. He's good. He's okay.
Okay.
Yeah, he's good. Great. Just don't miss it again. Please. I cannot continue to enable people. I have enough drama in my life. I don't need any more. Every time you miss a drug test, it's just, it's going to go downhill. I'm happy that you tested negative today. Just keep it up. Do not use. A lot of this life is who you hang out with. If you hang out with other people who are using, they may not be on bond. They're not going to care for you. They just want to party with you. If you do this and you test positive again, it's not going to go well, or it may not go well between us. Do you understand? Just stay in contact with your lawyer. do not pick up any new cases, all right? Okay, man, good job. Please. We'll get you out of here.
This one was supposed to have 2 weeks for a job. It's my first week. Does he have one Stacy or? Does he?
I don't know. We'll just give her time. She's here and it's already 1:15.
That's 9:03.
How's 9:03?
I'm sorry, were you talking to me, Judge?
Yeah, don't worry. We'll reset you to 9:03. How's that?
9:03 is fine, Judge.
Okay. All right.
So just one more. This is on Caden West, so, we need the date that he's going to be. With
Oh, right. On Mr. West, do you know when he's going to be released?
I don't think it's gonna be before his case is dismissed. He's set back on your docket on September 9th. He's probably gonna still be in that location in Dallas until then.
Okay, I guess, do you know where that location is? Do you have the phone number?
We have the location, we have the phone number, but because it's medical, they won't give us any information.
Will they
Well,
tell you whether he's
I'm
even
telling you, he's
there?
still there. He's still there.
I'm sorry.
Yeah, but my only fear is that he gets released. He's in complete non-compliance with the device at this moment. So if he takes off and he doesn't have the device like he should be, I'm issuing a warrant, okay? It's just been
Okay,
too
yeah.
much.
I think this
So
is kind of what we
please.
discussed when you weren't here last week. He's on 24-hour supervision right now where he is. So I
Okay.
think the state and I agreed that it's kind of counterproductive for him to have a GPS and be monitored.
Stacy, I agree with you, but all I want to know is the day that he's going to get released. That's all I want to know, unless it gets dismissed before that. Do you guys know who we're talking about? West? So West is in a treatment facility now.
Yes, Judge.
But I gave him a device so that we know where he was at, but it's,
That's the one that we called, right? That we were calling the facility. Yes, Judge, I remember.
Oh, yeah.
what offer do you have now? Do you have a dismissal offer?
Can I get the call?
It's 261-2376.
Yeah, when I called the facility, judge, I would not answer. They said that they.
Yeah, it's a HIPAA. They're not gonna, yeah. We're just gonna have to go through Stacy.
I mean, he's complied with everything as part of his mental health PTI.
Yes, Judge.
The only condition was that he needed to get treated.
If the court is okay.
And which he's done.
His felony court did dismiss the case for mental health treatment. If the court would be okay with that as well, we would do that.
So you want to dismiss it now?
Yes, Judge. This is-
Yeah, well, that's up to you. If you want to dismiss it, then I mean,
The biggest thing, Judge, was to make sure that he got into treatment. It looks like he has been in treatment.
yeah, he's been in for a while, right? Stace? I know that he's been in a while
Yes.
because we've gotten drug tests from him and they've been,
He's been in treatment
Negative.
for 6 weeks.
yeah. All right, they're gonna dismiss it now, Stace.
Thank you.
Okay, we're done.
Thank you.
So
Okay.
just kill the conditions. Okay, cool.
Yeah.
What are we saying for bond? Or?
15,002. Yeah. Hey, can I give you one more cause number, please?
Yes, Judge.
We need to do a cite and release, if you don't mind reading probable cause. 2634358 on a Johnson.
Mr. Johnson, Judge. Miss Johnson, sorry, Miss Johnson.
Oh, is it? Yeah, Miss Johnson, right?
Officers conducted a traffic stop for you didn't highlight meeting, the violator turned onto public road in Harris County, Texas. Defendant, who couldn't provide any form of financial responsibility. Officers were able to show that her driver's license was not eligible due to the following suspensions, which included EWLIs, multiple violations going back to 2017 of driving while license invalid. I think it's 2016 driving and financial responsibility.
Got it. Okay, I'll find PC then.
Yeah, it's.
Hey, so now GPS with curfew, so we know where he is at all times, the proper